Good morning so far. Have a seat. Make sure you pull the microphone towards you. Make sure everybody can hear you. All right, when we last left off, we were at the Defense Cross.
Yes, Your Honor. Good morning, Ms. Grant.
Hi.
Hi. We didn't have a chance to formally meet yesterday,
Sorry.
Mike. It's right here. We didn't have a chance to formally meet yesterday, but my name is Nico the Hood, and I'm one of the lawyers that represents these three officers, okay? Have you ever testified before?
Yes.
How many times?
Too many to count.
Too many to count. 17 years, you have a lot of
Yes.
experience. Okay. Well, then I'm going to ask you some questions. It's going to be relatively short. If you don't understand my question, please ask me to repeat it. Okay? I think, Judge Mariposa,
Yes.
I think we use a lot of terms, and we take for granted that the jury knows what we're talking about. So I want to talk to you, and I'm going to use a fake gun. You know this is a fake gun. And so just so people know about a firearm, this is a replica of, looks like a Glock firearm, correct?
Yes.
And this is a standard issue that Bexar County Sheriff carries, but not SAPD.
Yes.
SAPD carries Smith & Wesson,
Yes.
but the functions are similar.
Yes, sir.
So this thing in the middle, this is called the mag well, correct?
Yes.
That's where we call it the handle. And even though it's a fake gun, I always treat a weapon like it's loaded, even a fake one, right? And so I'm indexing my finger, and so I'm holding this weapon down, and this is the handle, and the inside of the handle is the mag well, correct?
Yes, sir.
And you were talking about these magazines. The magazines are these items that you put inside where the bullets are held, right?
Yes.
And the bullet is fed into the chamber, and then when you pull the trigger, if it's a striker fire weapon, it'll hit the shell, the primer, and then shoot the projectile out.
Yes.
And so when you were showing the magazine to the jury yesterday, it's not a magazine that we read, right?
No.
And so in the gun world, we know when somebody doesn't know a lot about firearms when they call the magazine a clip, right?
Yes.
But you didn't do that. You called it a magazine, right?
Yes, sir.
And so and that's what you were counting. And so this is called the slide.
Yes.
And inside there is the chamber, right?
Yes, sir.
And so when you were talking about how they loaded the weapon to have a full 17 with one in the chamber, what a law enforcement officer would do is they would take their magazine, they would load the magazine. I don't mean to give you my back, I'm sorry. They would load the magazine, right? And they would call racking the chamber. They can do
Wrap
it two
the
ways.
slide, yes.
Right, with the slide, I'm sorry. They rack the slide. They can do it either this way or they can do it this way, correct?
Yes,
And then
sir.
they would holster their weapon and they would have one in the chamber and then a full magazine.
Yes.
And this is called the beaver tail.
No, I don't know.
You know what that's
about
called, but that's where you put your handle in there. Just wanted to get all that cleared up. So I'm gonna ask you just briefly about that in a little while. But what I noticed, yesterday, and before I get to what exactly you did as a CSI in your portion of the investigation, everything that you explained to the jury yesterday is protocol, right?
Yes.
I mean, these are the exact procedures you follow on any officer-involved shooting, correct?
Yes, sir.
I mean, this wasn't because they were suspects. It was like any officer that's involved in a shooting is going to go through the exact protocol that you explained to this jury yesterday, right?
Yes, sir.
You were not notified that they were a suspect at all.
No.
The pictures that you took of these three officers, they were actually in their uniform, correct?
Yes.
Those were not mug shots.
No.
Those were just part of your protocol for any officer that's involved in a discharge of their weapon while they're on duty.
Yes, sir.
Okay. Now, part of that process, I want to talk to you about that, is after that they went through their investigation, the portion that you covered, they were offered to talk to ministers or counselors, correct?
As far as I know.
Right, because that's part of the protocol. Because you have to answer for the her, she'll get mad at you. Say yes, ma'am.
Yes, sir.
Okay. You don't have to say yes, ma'am, but I do that. So they're offered, because that's traumatic. In your experience, you know that when an officer involved in a shooting, especially when the unfortunate situation where someone loses their life, that can be traumatic.
Yes.
And part of the protocol, and you're not sure, but they were offered to speak to ministers and or counselors.
Yes, as far as I know.
Right. And also part of that protocol is you're aware that Sergeant Rivera went with them to what we call the ready room in headquarters to issue them duty weapons again. You're aware of that?
I don't know what happens once I'm done about when they go to get a new weapon.
But that's part of the protocol, that an officer, if they're not a suspect, will be issued a duty weapon because they're not a suspect and they're gonna get a weapon so they can carry, correct?
Objection's been asked and answered.
I didn't ask it that way, Judge.
Overruled.
If you know.
I don't know anything about that part of it.
But you know that there's a ready room at headquarters and there's an armory at the academy. Do you know that?
Yes.
Okay. And the armory at the academy is when someone goes through those 8 months, they're issued a weapon, a duty weapon, correct?
Yes.
A ready room at the headquarters is kind of a mini armory that they can't always go to the academy to reissue weapons if an officer needs one, right?
As far as I know, I don't know where that room is.
I didn't ask you that. I'm just saying there is one though at headquarters, right? A ready room.
That I'm not sure of.
Okay, so in your 17 years, you have not been privy to
I
that
don't
information.
I don't go anything past when they go to get their firearm.
But I guess my question is, you know that they get firearms once?
Yes.
Okay, that's what my question. So I want to direct your attention now kind of to the process that you did when you took pictures and things of that nature and collected some evidence, okay? I am not going to go through the magazines with you and the rounds, okay? We're not going to do that. You did that yesterday with the government. I want to talk about a portion of your investigation, or not investigation, your evidence collecting, that the state did not go over with you, and it's called GSR. Can you explain to the jury what GSR is?
It's a gunshot residue test.
And gunshot residue is made up of 3 particles, correct?
Yes.
Antimony, barium, and I believe lead, right?
Yes, I think
And
so.
those 3 particles make up gunpowder, correct?
Yes.
May I push, Judge?
Yes.
And so when anybody, not just an officer, when anybody discharges a firearm, then there's going to be gunpowder because it's an explosion, and then there's going to be evidence that that weapon was fired, correct?
Yes.
And that gunpowder made up of those 3 particles can be left on either items, hands, wrists, forearms, things of that nature, right?
Yes, sir.
And so GSR just essentially means one of 3 things. Do you recall what those 3 things are?
I'm not sure what you're asking.
Well, I mean, GSR proves that someone either fired a gun, correct?
Yes.
Either handled a gun after it had been fired, correct?
Yes.
Or was in the vicinity. If Mr. Lunin shot a weapon and I was close to him, I may have GSR on me from him firing a weapon, correct? That's the 3rd.
Yes, possibly.
And that's all that means. It's just these particles from somebody shooting a gun around you, you shooting a weapon, or you picking up a weapon that had been shot already. That just means some particles can be on you.
Yes.
And whether there's 25, 30 particles or 1, there's GSR on that individual. Is that a fair statement?
Yes.
But now when you did GSR on all 3 of these individuals, correct?
I GSR'd 2 of them, and Oliva GSR'd the sergeant.
Okay, so you did Officer Alejandro and Officer Villalobos.
Yes.
But on Officer Villalobos, it was a little more complicated because he had washed his hands, correct?
Yes, that's part of the questions that are asked. Have you washed your hands since this happened?
And Judge, may I approach the witness?
Yes.
You made a report?
Yes.
Okay, I'm going to hand you a copy of the report. It's not going to be entered into evidence, but if you need to refresh your memory. Now, there was something specific about Officer Villalobos. So Officer Villalobos, he had washed his hands, and that's not typical after a shooting incident, correct?
That depends. Most of the time, not.
Most of the time not, but in this situation, Officer Villalobos was attempting life-saving measures on the suspect. That's what you wrote in your report,
Yes,
correct?
that's what he told me.
And so Officer Villalobos, because he was trying to save Ms. Perez's life, he had a good amount of blood on his hands, so he had to wash his hands, right?
That's what he told me.
Right. Well, and that's what the evidence showed after you talked to other people as well, correct?
He's the only one that told me that.
Okay. But if there's other evidence of that, you have no reason to disbelieve me or him. Okay. But in your report, you designated Ms. Perez, you have SP1. Tell the jury what SP1 means, please.
SP1 means suspect.
And what is a suspect in your training experience?
Someone who, I don't really know exactly how to describe it. Someone who's suspected of committing a crime or suspected of some type of action.
Right, and it's kind of weird to give the definition as part of the word, right? Suspect, suspected. But that you're exactly right. If someone is a suspect, they are suspected of breaking the law.
Yes, as far as this is concerned, yes.
Right, and you had information, and you put in your report that Ms. Perez at this stage was actually a suspect.
Yes,
And you know that officers, not these specific because you don't have personal knowledge, are reissued firearms after an officer-involved shootings if they're not suspects, correct?
as far as I know.
Pass the witness. Thank you, Ms. Crane.
Pass the microphone.
Yes.
Pass the microphone, please.
Oh, here's the mic.
May I see the photograph that was introduced in the evidence for Officer Villalobos? Christian? May I approach the projector?
Yes.
Oops. Keep going. Is there any way to zoom in?
There is.
To the doctor. Okay.
Right here. Where do you want to come in?
To the Red Cross. All right, I represent to you that this has been marked and introduced into evidence as State Exhibit Number 175. You're familiar with the MedTac program?
Somewhat.
Okay, what is your understanding of the MedTac program?
That there's officers that are trained to do immediate life-saving measures.
And are
they
they
should.
required to carry medical equipment with them?
I've only seen what they carry on their belt. They have a tourniquet on their belt. I'm not sure what else is in there.
All right. And would you agree with me that what we see here, this cross on this packet, is part of the MedTac gear that officers are required to carry?
Yes, if they're certified in MedTech.
All right. And only people who are certified in MedTech can carry that, correct?
As far as I know,
All
I'm
right.
not sure.
And so would you agree that in Officer Villalobos' photograph, we do see that he carries the required MedTac gear?
Yes, from what I can tell.
All right. And you made sure that he didn't take any equipment off of him before you took a photograph of him, correct?
Yes.
All right. So, even though, let me back up a little bit. I understand that you're an instructor on techniques for CSIs.
Not anymore.
Okay, but you used to be.
Yes.
When were you instructor?
Up until 2022.
All right. So how long were you an instructor?
I was only an instructor on my shift
Okay, but how long were you on?
from probably maybe 2013 to 2022 off and on.
So about 7 years you were an instructor?
Yes, give or take.
All right, and also were you, if I'm not mistaken, you're a level 3? CSI?
No,
You're level
2.
2, okay. All right, and you agree that chain of custody is important, correct?
Yes, sir.
And you've never had a problem with chain of custody before, have you?
Not that I know of.
All right. And I take it that you take pride in the fact that you've never had a problem with chain of custody before, correct?
I would say so.
And you haven't ever, even today, you haven't had a problem with chain of custody, correct?
As far as I know.
All right. And you would agree with me that if you don't document that you teach people that if you fail to document, you might as well admit that something didn't happen, correct? You teach that in your CSI training, correct?
Yes.
All right. And a good CSI, if there's an error, would document the error immediately upon discovering the error, correct?
Yes.
All right. And I'm not saying you made any errors. I want to make that clear. But since you didn't document that you had any errors, we can agree, would you not, that you had no errors in this case, correct?
As far as I know.
All right. And I think Mr. Lahuda asked you about protocol. Would you agree with me that on average in the last few years, San Antonio has averaged anywhere between 15 to 22 officer-involved shootings per year?
I'm not sure of the number.
Would that sound about right?
Possibly.
All right. And so in all the officer-involved shootings that you have handled, you've never seen someone arrested within hours of the shooting, have you?
No.
All right. And my understanding is that you submitted your report and it was not approved until months later. Is that correct?
That I don't know. We place our report into the report system, and then it goes through a process of being approved.
So, if I'm not mistaken, the report system is called Mark 46, is that correct?
Mark 43.
43, okay, I forgot the numbers, I'm sorry. But you are correct, Mark 43, it's a computerized system, correct?
Yes, sir.
And you submit it digitally into the system, Mark 43, and at some point in time, your supervisor approves the report, correct?
Yes. I'm not sure who approved this one because it was,
And it's not final until it's approved, correct?
as far as I know.
Can you look at your report and tell us when it was approved?
It just has my name on it on the date that I submitted it. And then it has Sergeant Whittaky approving it August the 28th of 2023.
Okay, so August the 28th, that's basically 2 months later, correct?
Yes, sir.
All right. And it's not finalized until it's approved, correct?
As far as I know, it goes in the system and I don't know when it's approved. I only know if something gets kicked back and I have to correct it.
All right, and I understand that you were dispatched to the Public Safety Headquarters after 2 o'clock, but you had to wait a long time for the officers to arrive, correct?
Yes, I think so.
All right, and they didn't arrive until after 4:30 or so. Would that sound right?
Yeah, I think so.
All right, 4:30 in the morning. And they arrived at different times, correct?
That I'm not sure of.
Okay. And not to belabor the point, but the collection of the guns is standard protocol whether someone engaged in any misconduct or their conduct was justified. Would you agree?
Yes, sir.
All right. And in your report, do you agree that you listed 8 different addresses for Melissa Perez?
That's something that gets pulled over when you pull the person's name into your report.
Okay.
So I didn't list all those. That was something that was already there and it got pulled into the report.
All right, fair enough. And I don't want to misstate what you did, but regardless, it is part of your report. Would you agree?
Yes, sir.
Okay, and it's pulled over because there's records of all those addresses in the SAPD database, that those are Melissa Perez's addresses, correct?
Yes, I think so. That's what that is.
All right, and would you agree that each of those addresses was imported into the SAPD database at one time when officers had dealing with her?
I would say so.
So, can we deduce from your report that on at least 8 prior occasions, police had dealings with Melissa Perez?
I guess. I'm not really sure how those addresses get put in.
Okay. Fair enough, but would it be consistent with the reality that police had 8 prior encounters with Melissa Perez? Would it be consistent with?
I would say so.
Objection, Your Honor. It's improper bolstering. The witnesses said she doesn't know how they get pulled in.
Well, the question was, would it be consistent with, and she can answer that.
It's not bolstering for sure, Judge.
No.
And I heard your answer, but I'm not sure the court reporter was able to take it down or if the jurors heard. Could you repeat your answer?
As far as I know, that would be that they had some dealing with her at one of those addresses, why it might be put in there.
And when you say they, we're talking about SAPD officers, correct?
Yes, as far as I know.
All right, now, I want to be sure that all 3 officers, would you agree with me that when they submitted to the protocol that you're required to perform, that they were cooperative?
Yes, sir.
And you would agree with me that they were respectful to you?
Yes, sir.
And you would agree with me that no one said to you or to them that they were under arrest?
I never heard anyone say that.
And no one told them or you that they were a suspect in the crime, correct?
That was never stated to me.
All right. Now, you've been present when officers have surrendered their weapons, correct?
In what context are you talking?
When officers have had their weapons taken away from them for whatever reason, you've been present.
Yes.
All right. At any time before the officers left, were any additional weapons taken away from them?
Not that I know of.
So I want to be clear, and I know that you testified in answer to Mr. LaHood's question, but you don't know whether they were reissued weapons after you took their weapons. My question is, I want you to assume that they were reissued weapons. If they were reissued weapons, you did not participate in taking those weapons away. Would you agree?
No, sir, I didn't.
All right. Ask the witness.
Judge, we have no questions. Thank you.
I have no questions for this, further question with this witness, Your Honor.
All right.
May she be excused.
Yes, you may do.
Thank you. There's the copy of it.
Would you pass that to the states too?
Right, State, you can call your next witness.
State calls Holly Warden.
Swear you in. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you may need to adjust the microphone, make sure we can hear you. Can you introduce yourself to the jury and spell your name for the court reporter, please?
Good morning. My name is Holly Worden. That is spelled HOLLIWORDEN. And I am a forensic scientist supervisor in the firearm and toolmark section of the Bexar County Crime Lab.
Can you tap on that mic? Okay. You may want to pull it a little closer.
Okay.
All right. State.
Good morning, Ms. Warden.
Good morning.
you had mentioned in your introduction yourself that you are a supervisor at the Bexar County Forensic Science Center in the toolmark examination section. Is that right?
Yes, it's called the firearm and toolmark section.
And can you tell us a little bit about how long you worked there and what training, education, experience you had to qualify you for that position?
So I have been with the Bexar County Crime Lab for 6 years, and I've been in this discipline a total of 10 years. The first 2 years of being in the discipline, I was a trainee at a different agency in Arizona, and so the training program is typically 2 years of specialized training. 1 year was in-house at that laboratory I was at, and the other year I attended the National Firearm Examiner Academy, which is hosted by the ATF, and that covers all the various aspects of my training, such as examining and function testing firearms, performing microscopic comparisons of fired bullets, cartridge cases, and other tool marks, doing things like serial number restorations on firearms and distance determinations. Besides doing that training, I had to complete numerous competency tests and annual proficiency tests to ensure that my work is correct. And besides that, I also have a Bachelor of Science in Forensic Science and a Master of Science in Forensic Sciences.
The laboratory that you work for, does it require some kind of accreditation by the state?
Yes, so our laboratory, the Bexar County Crime Lab, is accredited by both the Texas Forensic Science Commission as well as ANAB, which stands for the American National Standards Institute National Accreditation Board.
And how many other people at the Bexar County Forensic Science Center do firearm toolmark examinations?
So currently there are 4 of us total.
So tell us how a firearm can be examined to determine whether or not it fired a particular cartridge and bullet.
So as I mentioned, I examine and function test firearms. So to determine if something came from a firearm, I would first need to examine a firearm itself. And so what I do there is I perform a detailed examination of a firearm, determine its caliber or the size of ammunition that goes in it, its make, model, serial number, what type of firearm it is, how does it operate, does it have any safeties, are those operating. Once I do all of my initial testing, then I do test fire that firearm and recover fired bullets and fired cartridge cases. Now, those fired bullets and cartridge cases I know came from that firearm because I fired them myself. And so those test fires I produce end up being my known standards that I can then compare to any fired bullets or cartridge case related evidence. So to get into that, let me also explain what a cartridge is. So I have this large demonstrative aid of an unfired cartridge, and I'll just break down the parts of it so you are aware. So a cartridge is the unit of ammunition. It's made up of 4 parts. These include the bullet or the projectile that leaves the barrel of the firearm, the cartridge case, which contains the gunpowder and also a primer. The cartridge case primer is what is struck by the firing pin of a firearm, and that is what initiates the firing process. So for example, if you pull the trigger of a firearm, firing pin is struck, that ignites the gunpowder inside of the case, and then pressures build. Those pressures will push the bullet out of the case through the barrel of the firearm, where the bullet will then exit. And then if we're talking about, for example, semi-automatic pistols, that cartridge case will then be extracted and ejected or kicked out of the firearm. So in that firing process of as I just mentioned, there are tool marks that are left on the fired bullets and on the fired cartridge cases. And every firearm leaves a distinct pattern of tool marks on the bullet and on the cartridge case. And so I look at that pattern. It's typically reproducible. I look at that pattern with a instrument called a comparison microscope. That is essentially like two microscopes that are connected by something called an optical bridge, and that allows me to look at two items, like two cartridge cases or two bullets, at the same time and at the same magnification. So what I'm doing is I'm looking at the microscopic pattern of tool marks that are left on those. So, as I mentioned initially, test firing the firearm, I produce my known standards. And then those known standards, I then compare to any submitted evidence, bullets, or cartridge cases. And if I see a pattern of tool marks that is reproducing and shows sufficient agreement, that I can form the expert opinion that they were fired in or from that firearm.
So does each firearm then that fires and the firing pin strike the casing in the back, does it leave unique marks, unique to the particular firearm?
Yes, so it'll be a distinct pattern or signature. Even if the firearms are the same make and model, they each have their own signature that is left on the cartridge case, from the firing pin, from different surfaces that touch this cartridge case during the firing process. And then the same goes for the barrel, or for the bullet, as it passes through the barrel, it engages with the rifling in the barrel, and that leaves scrapes all over the surface of the bullet that reproduce.
Go a little bit more for the jury about what rifling is inside the barrel.
So rifling is a manufacturing process that most firearms, like any semi-automatic pistols, are going to have, in which there are spiralized grooves that are cut into the inside of a barrel, and basically what those do is impart spin on the bullet. So as the bullet engages under the high pressure, it digs into that rifling, and that rifling either rotates to the right or to the left, and that causes the bullet to spin in flight, and that keeps it stable. For example, if you were to think about throwing a football, and you know that the football like kind of spirals when you throw it, that's more stable than if it were to tumble. And so that's the purpose of rifling.
Okay, and with each firearm that you would test and fire a bullet through that barrel, will it leave unique marks on that bullet, unique to that particular firearm?
Yes.
The science of tool mark examination with respect to firearms, how long has that been around?
It's been around for over 100 years.
Okay, are you a member of any professional organizations that relate to firearm tool mark exams?
Yes, so the main international organization is called the Association of Firearm and Tool Mark Examiners, and I am a distinguished member of that.
And even though you're a supervisor of that section now, do you on a daily basis perform these kinds of comparisons?
Yes, I do.
I want to draw your attention back to your laboratory number 23-03995, in which you were asked to look at some evidence sent over to you by the San Antonio Police Department back around on or about September 14th, 2023. Do you remember having any involvement in that examination?
Yes.
What did the San Antonio Police Department bring to the crime lab for you to look at?
So initially they brought several items of evidence. I received 3 firearms, each that contained also unfired cartridges and magazine. I also received 16 fired cartridge cases and fired bullets and fragments that were collected from the medical examiner's office.
And would you be able to recognize those items if you saw them again?
Yes, I would.
How would you be able to do that?
So I would be able to recognize one, the CIL number, or that criminal investigation number, a criminal investigation laboratory number, which is the number that was mentioned, 23-03995. And then I would also see on the packaging my initials, the date that I received and opened that package, the item number that I gave it for my examination, and I should also see any seals from when I resealed the evidence.
As far as procedures at the crime lab, does the crime lab accept any packaging or items of evidence that are not in a sealed container?
No.
May I approach, Your Honor?
Yes.
Space. Would you like to use gloves?
Sure.
I'm going to show you items in evidence marked States Exhibits 185, 186, and 187. Okay. I'll start with 185 here. Can you look at that packaging there? And can you tell me if you recognize it?
I do recognize it. I see the CIL number, my item number, my initials, and multiple dates of when I had opened this package.
Okay, and you've opened it more than once,
Yes.
right? And each time that you opened it after you were done with your examination, did you reseal it?
I did.
Okay.
I have multiple seals on here, on the side here.
And you're pointing to kind of the red evidence tape that is on there, right?
Yes, the red evidence tape has my initials and the date on it.
Okay. And if you'll look inside that packaging. And there's more packaging, right?
Yes.
Go ahead and empty all the stuff out of there. Is that empty?
Yes.
How many items are inside that?
So there are 3 packages.
3
inside.
packages. All right, so let's start with
This one.
that one here.
Oh,
Marked as 185A?
Yes.
Do you recognize that?
Yes, I do.
is
This box contains my test-fired bullets and cartridge cases that I had produced using some of the evidence ammunition that I received.
Okay, so when you first opened that package, when it first came to you, first it was sealed,
Correct.
right? It didn't contain that box in there, right?
No, it did not.
Okay. You put that box in there, right?
I did.
After you test-fired 2 of the cartridge casings that were included in this grouping?
So 2 of the unfired cartridges that came in one of these packages, I used for my test firing.
You had talked about how you, in the purpose of making a comparison, you yourself want to see what markings the particular gun made on a fired cartridge casing, right?
Correct.
And so you fired 2 of the ammunition that was with the gun.
Correct.
Okay. And then after they were fired, that results in a casing and a bullet.
Correct.
Right? And
yes.
did you recover each of those items?
I did.
And are they in that box?
They are in this box.
So how many items should be in that box?
So there should be 2 bullets and 2 cartridge cases.
Okay. Second one is marked. I'm going to do it in order here. Is this a 185B?
Yes.
Do you recognize that?
Yes.
What is 185B?
So 185B, on the outer packaging, I recognize the same markings that I left on it. It contains more items. Did you want me to?
Okay, tell me what you see in there.
Okay, I see a magazine and some unfired cartridges and another envelope that should contain 1 more unfired cartridge.
Okay, and these are items you've seen before?
Yes.
And these are items that were in this grouping when you got it initially,
Yes.
right? And so with respect to the the envelope that's inside. It's marked 185B1, is that right?
Yes.
Did you do any testing on that?
So I would have examined this and taken notes on it to evaluate what it was.
Okay, and what's contained in 185B1?
So this should contain one unfired cartridge.
Okay. And so you didn't fire it, you left it unfired?
I left that
right?
one unfired,
Okay.
yes.
And the other items, you mentioned there's a magazine in there, right?
Yes.
What is that marked?
That is marked as State's Exhibit 185B2.
185B2, okay. And also in there are, can you get them? You're not shy about touching ballistic evidence, are you?
No.
How many of those you dropping back in the bag as you count them?
Okay. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
Okay. And how many rounds does that magazine hold? Cover, if you know.
It should be, could I refer to my notes?
Sure.
This was 17.
So that's 17, right?
Yes.
And the number of bullets that were unfired that you dropped in there is how many?
There were 12 unfired cartridges in there.
Okay, at least 5, right?
Yes.
Right. And of those 5, you used 2 of them for your test fires.
I used 2 of, yes, so there were originally 14 in there.
So the original 14, and now there are 12,
Correct.
right? And that would mark the number that are in that magazine, would fill that magazine. I'm sorry, except it'd be missing 3.
Right.
It'd be missing 3 rounds, right?
Yes. Yes.
Okay. You can put the magazine back in here. Okay, 6, 8. And then 185D. Do you recognize the packaging in 185D?
I do.
And how are you able to recognize it?
So I recognize the CIL number, my item number, which was 4-1, my initials, and the numerous dates that I wrote on it.
What's going to be in that package?
This is going to be a firearm.
Okay. And did you mark this firearm by a serial number?
So that the serial number would be documented in my notes and on my report.
Okay. Go ahead and open it here. It looks like it's been opened here. When we just look at that.
Just verifying that the firearm is safe. So for one, I recognize I wrote my CIL number, item number, initials on this
How did you do that?
with a Sharpie marker.
Okay.
And then there's also, it does have a serial number.
Okay, and the serial number of 185D is what?
So it reads NMR 8375.
8375, right?
Yes.
Okay, so this is the first one we're going. Do you list it by item number? Do you have this as far as the 3 firearms that you tested? Do you have this with labels in particular item number?
Yes, so this is my item 4-1.
This is your item 4-1.
Yes.
Okay. Now, with respect to item 4-1 or State's Exhibit, what is it, 185D1, I think. Probably there's probably a sticker on it.
Or 185D1, yes.
Right there, right? You fired this weapon?
I did.
With 2 of the Hornady rounds that were in the packaging,
Yes.
right? And in those rounds, the bullet and the casings for each of those rounds is in here.
Yes.
Right. Did you have the opportunity then to compare the test fired rounds from here with other items of evidence?
I did.
Okay. Let me walk around here. Did we get too messy? Okay, I'm going to show you what's been marked as state's exhibits. 153. You recognize that?
I do.
What is state's exhibit 153?
So this package should contain bullet-related evidence.
Okay, you've seen it before?
Yes, I have.
How do you know?
The CIL number, my item number, my initials, and the date.
And did you do some testing on the item inside there?
Yes.
And by those markings, you know that it's an item you tested?
Yes.
Go ahead and look inside. What's inside there? What you expected to find in there?
Yes.
What is, okay, first I'll point to what's been marked as State's Exhibit 153A. What is that?
So this package, inner package, just contains, there's more items inside of here.
Okay.
And I recognize, again, CIL number, my item number, date and initials, my seals on it.
So you've opened that package up before?
Yes.
It was sealed when you opened it?
Yes.
Initially, right?
Initially,
And then when you were done examining the contents, did you reseal it again?
I did.
Okay. Go ahead and look inside. What's
There are several more envelopes.
okay? You recognize each of these envelopes?
I do.
And let me put it kind of in order here. It's 153A1, A2, A3, A4, and A5. Right?
Yes.
Let's start with State's Exhibit 153A1. Do you recognize that?
I recognize the packaging on it, yes.
Okay. Is this an item that you did any testing on?
It is not, but I did mark the outside envelope. I just did not open it.
Okay, to confirm that you had received it with this other grouping, right?
Correct.
What is contained in this item according to the placard on there?
Yes, according to the label, it is left fingernail clippings with clipper from the Bexar County Medical Examiner's Office.
Okay, and did you have that marked in your report of you having received that with this other evidence?
I did.
Okay, you can drop that back in the bag. 153A3, seen that before?
Yes. So this is my item 10-5, and it was labeled as right fingernail clippings with clipper. I also did not open this package.
You had no kind of forensic firearm or tool mark examination to do on that package, right?
Correct.
But you put that one in the 53. Let's go A4. What's contained in there? I mean, have you seen that before?
Yes, I have. So this is my item 10-2. I did open this one.
Okay, and what's contained in there?
So I described it as 3 lead fragments.
Okay, and was there any kind of testing or tool mark examination you could do on those fragments?
I did do initial examinations of them. I did weigh them and take photographs, but there were no tool marks present on them, so I couldn't do any type of microscopic comparison or determination if they were from a bullet or if they were a particular caliber or anything like that.
Do you know that it's lead?
It is consistent with lead from all of my experience looking at lead fragments.
And bullets, that were part of these cartridge casings, we've got the Hornady cartridge casings or so. Do they expel a lead projectile?
So if I were to talk about the Hornady bullets that are what the duty weapons contain, the bullets themselves have a copper jacketing on the outside of them, and on the inside we call it the core, and that is where there's lead. And then they also have a what we call a red polymer tip on the end of them. They're a type of hollow point bullet. So upon impact, they are intended to expand.
Okay. You can put that item. Exhibit 153A5. Is that an item you've seen before?
Yes, it is.
And did you have any testing to do on that item?
I did examine it. I opened up the packaging to determine what it might be. So this was my item 10-3, and
I'm sorry to interrupt you. How did you describe what you saw inside that envelope?
my description was unknown material.
Okay. Did you do any testing on that?
I just filled out initial notes of what I could, but it does not appear to be consistent with a bullet or firearm related evidence.
Okay, you can put that in. 155A3. Have you seen that before?
Yes.
And tell us what that is.
So this is my item 10-1, and this is, again, from the Bexar County Medical Examiner's Office based on the labeling on it. And I determined that this was a one-fired 9mm caliber jacketed bullet.
All right. And did you have the opportunity to do any testing on that bullet from the medical examiner's office?
I did.
And were you able to examine it under a comparison microscope?
Yes.
And were you able to compare it to any of the other weapons that were submitted to you as part of this grouping? Right.
Yes. So this bullet was compared to the 3 firearms that I examined.
Okay. Now, with respect to the Villalobos firearm that we have here, did it match the Villalobos firearm?
No.
Okay. Let's come back to that.
Okay. Let me just keep it to the
Okay.
side.
Let's leave that one out. Just put this to the side. Okay. And this contained that, right?
Yes.
All right. I'll show you what's been marked as State's Exhibit 156. Have you seen that before?
Yes, I have.
And when have you seen that before, and what do you expect to find inside it?
So I recognize my markings on it, CIL number, package item number, my initials, and the date that I opened it, my dates from sealing it. This should contain several fired cartridge cases.
Okay, go ahead and pour it out here and see if it contains what's left in there, right?
Yes, let me sort them.
156.
Or do
I believe it's 156A through P.
A through P, okay.
Do you recognize these envelopes if you kind of sort through them?
I do.
And again, how are you able to recognize them?
CIL number, my item numbers, my initials and date. So my item numbers for these would be 7-1 through 7-16.
So are these 16 cartridge cases?
Yes.
All right. And there are actually numbers on them. Apart from the exhibit numbers, there are big numbers 1 through 16, right? Are those numbers that were on the envelopes when they were submitted to you, or those numbers that you put on there?
Are you referring to These, yes.
It's the large numbers.
So those large numbers were already on the envelopes, and I think they're not quite 1 through 16, but they're
Oh, okay.
Several different. They each have their own number.
Okay, they each have a number, but they came to you from the San Antonio Police Department with a number on each of these small envelopes.
Correct.
Okay. And what were you asked to do with each of these cartridge casings in here?
So I was asked to examine them and then evaluate them to determine what firearm they may have been fired from.
Okay, just as a general class characterization or so, were all these cartridge casings, spent cartridge casings from the same make and brand of ammunition?
So yes, all the fire cartridge cases were Hornady 9mm Luger plus P caliber ammunition.
Okay. So we don't get these things confused. Okay. Of these rounds of ammunition here, did you find any of them that were fired by this handgun, 185D1?
Yes.
Okay. And how many of them?
So I determined that there were 3 cartridge cases of these 16.
And if you could point out which numbers they were. I'm sorry.
No. So for my numbers, it was 7-8, 7-9, and 7-11, which would have been, for the SAPD, that would have been 8, 9, and 11, I believe. Let's see. 8. 9. Oh, no, that's 11.
So these envelopes 8, 9, and 11, you looked at these in a comparison microscope
I did.
and compared them to the rounds that you fired through this handgun, Villalobos' handgun,
Yes.
and you determined that these were also fired from that same handgun.
Correct.
Right?
Yes.
3 of them.
3 of them.
Okay, let's put those in the bag. You have the bag there, and leave the rest of these out for now. Showing you what's been marked as State's Exhibit 157. I'm glad you're organized. 157, have you seen that before?
Yes, I have.
And when did you first see this item?
So I saw this, or I received this item in my custody and opened it on September 16th, 2024.
Okay, last year,
Last year.
right? And what's contained in that Exhibit 157?
So this contains 4 fired bullets.
And what were you asked to do with the 4 fired bullets?
Examine them and determine if they were fired from any of the 3 firearms that were submitted.
Okay, come look inside there. It is the 4 bullets that you had seen previously.
Yes, I recognize CIL number, my item number, initials, dates, and my seal on them.
And did you look at each one of those items contained in those envelopes under your comparison microscope?
I did.
And compare what you saw to the weapons that were submitted to you?
I did.
Okay, with respect to this weapon, the Villalobos weapon, we'll refer to it as, right? 185D1, were you able to determine if this weapon fired any of those spent bullets?
Yes, I did.
And which bullet was that?
That was my item 11-4, which was SAPD item E22
E22.
and State's Exhibit 158D.
Okay. So bullet E22 and the casing 8, 9, and 11, right? Sorry, I'm asking you to go back on what we already did.
But yes.
That's right, right?
Yes.
Okay. Let's put those away right now, just so it doesn't get too messy. And we'll come back. Go ahead and pack this weapon back up again. 185. There we go.
And then those as well, Brandon.
And these were the cartridge cases.
And magazines.
Magazine. Same one. Okay. Move to this next weapon. Case Exhibit 186. And I'm showing you the packaging of 186. Again, do you recognize it?
Yes, I do. I recognize the CIL number. That's still the same one. My item number, my initials, and my dates of opening it and sealing it.
And what is your item number on this one?
This is, the outer package is 5, so the contents inside will be 5 dash another number.
Okay, go ahead and look inside and see if it contains what you left in there.
This is 5-1. I recognize the same information, my item number, initials, date, CIL.
And is 185, I'm sorry, did it say 180, oh, sorry, it's 186C, right?
Yes,
And does it contain a firearm in that wrapping?
yes, it does.
And that is what, labeled as what?
186C1,
Okay, and can you look at the serial number of that?
yes. Let me just verify my item as well. Okay, the serial number I have for this firearm is NMR 7965.
Okay, and your item number was what on this one?
5-1.
5-1. Okay. So according to testimony thus far, this is Flores' firearm. I don't know if you have it by name or not, but this is your serial number, right?
You said 7965. Yes, I have that as Flores.
Okay. So Flores' firearm. Again, you can kind of wrap that back up. And are we on this one here? Is it,
Yes.
Right, 186. So taking the other items out of 186, right? We have 186B. You recognize this?
Yes, I do.
And same markings, CIL, your initials,
Yes.
your sealing tape.
Yes.
Okay. What do we expect to find in there?
This should be a magazine and unfired cartridges.
Just like from the last one. Take a look in there and see if it contains those items.
It does, and then it looks like one more item got put in here.
Okay, what item is that?
My test fires.
Okay, your test fires. What is that marked as?
My test fires are marked as 186A.
And that's the kind of the tiny box, right?
Yes.
And it contains 2 test fires, which is 2 cartridges, two bullets.
2 cartridge cases and 2 bullets.
Okay.
Yes. Yes.
And what else do you find in there? The magazine.
The magazine, which is 186B2.
Okay. And what else is in there?
There's one package that contains 1 unfired cartridge.
Okay. This is the round from the chamber.
Yes.
Okay, and used into the same way. How many unfired cartridges do we have?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
Okay, just like the other weapon, 12 12 cartridge casings, which means, and you fired 2 of them,
So,
right?
yes, so 12 cartridges, and then these 2 test fires were originally with those, so there was originally 14.
And if the magazine holds 17, then that means there's 3 missing,
Yes,
right? Okay, we'll put, that was in here too, right? The magazine?
oh, yes, both of these,
The magazine? No, okay.
and then that, this would just be in
We'll hang
there.
on that for now. Okay. So, did you, in the same way that we talked about with Villalobos' weapon, on Flores' weapon, take the test fires that you had and look at them under the comparison microscope and compare it to these casings and bullet fragments that we've talked about earlier?
Yes.
Okay. And what were your findings about which of these, first of all, we'll start with the spent casings, right, that are remaining here, right?
Yes.
Which of the spent casings did you find, if any, that were fired from Sergeant Flores' gun?
So I had determined that 3 of the fired cartridge cases were fired in that firearm, and those were, for my numbers, 7-6, 7-7, and 7-10. For PD, SAPD, it was 6, 7, and 10.
6, 7, and 10.
7,
Right? So from their evidence markers, 6, 7, and 10?
correct.
Right.
Yes.
Okay, right there. And you've got those 3 right there?
Yes.
Okay. Those 3 expenders or casings, without the bullets been fired, these were shot by Sergeant Flores' gun, right?
Correct.
Okay. You can put those in that other bag. See what we've got left. And with respect to the bullet fragments that you examined, did you find any of the bullet fragments that were sent to you for examination were also fired from Sergeant Flores' firearm?
Yes. Yes, so the the bullet item 10-1 from the medical examiner's office, that bullet was fired from that firearm.
Okay, so the initial bullet, the only bullet you got from the medical examiner's office, right?
Correct.
That you tested was fired from Sergeant Flores' gun,
Yes.
right?
Yes.
How about any of the other bullets that were found and sent to you?
I did have one other bullet from a later examination.
Left it over here. Marked as case exhibit 155. Recognize that?
Yes.
Again, the packaging, the markings, the identification numbers.
Yes.
You've seen this before?
I have.
And what's contained in there?
This contains one fired bullet from one 9mm caliber jacketed bullet.
Okay. And when did this bullet come to your office for you to evaluate?
I evaluated it on October 10th, 2024, so about a year ago.
About a year ago. All right. So this one came later than all the other ones that you
Yes.
got. Right?
Yes.
All right. Take a look inside there. Does it contain what you expect it to contain?
Yes.
Is it a single envelope containing a single fired bullet?
Yes, it should be. The packaging is correct of what I would expect. Feels like there's one thing in there.
Okay. And what is that labeled?
So this is labeled my item 12-1. It also has an E1 on it.
Okay. Is there a spent bullet in there? I mean, is that what you left in that envelope?
That's what I left in there.
Okay, if you can open it and you want to look at it, I think there may be some scissors over there. Oh, did you? I can grab some more. Thank you. All right. Can you look at that? Is that the bullet that you examined, that you returned to that envelope?
It is.
Okay. And did you have a chance to look at that bullet, marked E1, under exhibit number 155A, under the comparison microscope?
I did.
And did you have an opportunity to compare that to the spent casings and bullets, I guess just the bullets, right, that were fired from Sergeant Flores' gun?
I did, yes.
And what was your conclusions in making that comparison?
So I determined that this bullet was also fired from that firearm, Sergeant Flores' firearm.
And you can put that back together. All 186 back together. Okay, we'll show you what's been marked as State Exhibit 187. What do you see there?
The outer envelope I recognize by CIL number, item number, initials, dates, and seals. So this package should contain a firearm, magazine, and cartridges from Officer Alejandro.
Okay, and you can look inside and see if it indeed does contain the firearm.
Firearm is safe. Just verifying. Okay, I recognize this firearm with my item number, CIL initials, and then the serial number on this firearm is NMR 3596.
Okay, and you have this as your item 6-1.
Correct.
Okay, you can return that to the packaging. And also in 187, we have an envelope, 187B, is that right?
Yes.
And what is 187B?
So that envelope, based on the markings, should contain a magazine and unfired cartridges.
Okay, and does it indeed?
Just the magazine,
What's it labeled?
187B2,
Thank you.
a singular, an envelope containing one cartridge, which is 187B1.
Okay, from the chamber.
And then
How many unfired rounds are in this grouping?
I have 5 unfired.
Okay. So 5 unfired rounds. You used 2.
This is my box containing the test fires, as it says on it, using those cartridges that I received. So there should be 2 fired cartridge cases and 2 fired bullets.
Okay, that you used for purposes of your comparisons, right? And
Yes.
so you had, how many rounds?
I had 5,
Five.
so 2 more,
5?
7.
That's 7?
Yes.
It holds 17,
Correct.
so it's missing 10,
Correct.
right? Okay. Put the magazine back. All right, did you then have the opportunity to test this firearm, 187C, against the casings
I did.
and the bullet fragments,
I did.
right? Okay, with respect to the casings now, did you find in these casings any of them that were fired from Officer Alejandro's gun?
I did.
And tell us which one.
Okay. So of my items, I had item 7-1, item 7-2, item 7-3, item 7-4, item 7-5, and then item 7-12, item 7-13, item 7-14, item 7-15, and item 7-16.
And with respect to the SAPD evidence numbers,
Yes.
which were those?
SAPD evidence numbers 1, 2, 3, 4, 5, and 14, 15, 16, 17, and 21.
One, 2, 3,
4, 5,
5, 14, 15,
16,
16,
17, and 21.
that's 10, right?
Correct, yes.
So we talked about 10 were missing? And
Yes.
You had 10 casings that you found that you can attribute to his gun,
Yes.
right? Okay. With respect to the bullet fragments you found, were you able to look at those in the microscope and find that any of those were fired by the same gun?
I did.
And which numbers were those?
Those were items 11-1, 11-2, and 11-3, or SAPD numbers E13, E18, E19.
E13, I'm sorry, E13, E18, and E19?
Yes. Those would have been in from here.
Okay, let's put these back in their respective bags. Okay, and just take a look at your notes. Did you do any other testing besides the things that we've talked about?
I think that was everything.
Okay. Thank you, Ms. Warden. I'll pass the witness.
May I proceed, Judge?
Yes. Well, let's take a short break. Members of the jury will let you know when we're ready.
All right, for the jury.
Maybe see.
All right, members of the jury, welcome back. Defense, your cross.
Yes, thanks. Mr. Warden, my name is Jason Ross, and I'm proud to represent these three officers and stand up for them. And I have a few questions for you. If I could approach them?
Yes.
You have your report up there?
Yes, I have 3 reports.
Okay, I guess the report where you did kind of most of the work, yes. The first one that would come in with the evidence submission. Can you look and tell me the date on that report?
Yes. So my initial report was September 14th, 2023.
And on September 14th, 2023, is that when you, we're kind of looking at this chart that the state's been working on, I don't know if you can see it, but is that when you had determined, I guess, originally the ME bullet from Sergeant Flores' gun and some of those other matches?
Yes, so that bullet and then the cartridge cases, the 16 cartridge cases were all in that first report.
Right, and so that would have been, I mean, we're talking September 14th, 2023, and that's when you would have been able to say, these are my findings.
Correct.
All right. So as far as, you know, in looking at this, I guess just maybe talking a little bit about it. I know the state went through it with you, but you and I know each other from doing this, but I've never, you had come right after I was a prosecutor there. But I did do a tour with Ed Wallace, and you guys give tours of your lab.
Yes, at times.
And you know, for prosecutors especially, it's important because what it does is it helps us to understand how to question you, because we can understand some of what you do, right?
Yes.
So as far as the test firing, when we talk about when you're test firing, you have like a room that has a huge like water tub in it, right?
Yes, so we have a firearm range, so we can shoot downrange, and then we have this big tank of water that we stick the muzzle end of the firearm in and can shoot, and that's how we recover our test-fired bullets.
And one of the things about that, the reason why is because as the bullet goes through the water, it'll slow down and eventually rest at the bottom, and then you can fish it out, and you have a pretty like pristine sample of the firearm or the tool marks that you're looking for, right?
Yes, so it keeps the bullet in pretty good condition for comparison purposes, yes.
But when bullets have been fired and hit objects and other things, they can be squashed, they can split, they can have all kinds of issues that can make it hard for you to make your analysis and your determination.
At times it can.
And so in this case, one of the things, may I approach the demonstrative?
Yes.
So one of the things that the state has pointed out is they've said you were able to match 3, I guess, fired rounds, at least the casings, to Sergeant Flores' gun, 10 to Officer Alejandro's gun, and 3 to Officer Villalobos' gun.
Yes.
Okay. So with that 10 though, that number 10 would be consistent if Officer Alejandro had a separate incident immediately before where he had to use deadly force in response to the threat of deadly force and fired 5 times, and then later he had to fire another 5 times in response to deadly force. 5 and 5, it would be consistent with you finding that 10, right?
Potentially, I just don't know that background.
Sure. And I guess my question really is like the way that you get them kind of, you don't get them like in time, you just get them all in a bunch.
Yes, so the way that those envelopes, when I open them up, that is how they came to me.
Right, and so when there's 10, you couldn't say, and you can't say like, oh, these 10 were fired all at one time. You don't know in which order and which part they were fired.
No, I don't know the order.
Sure, and so, but if it were that and it were divided, it would be 5, 0, 0, and then 5, 3, 3, right? If it were as I described it to you.
Sure, yes.
Okay. And of course, the body cams and everything else, that would be the best indicator of what actually happened there, right?
It would be something that could help.
Sure. So because I want to talk about, as far as, you said that, well, let's talk about hollow point real quick. So you described all of these rounds as coming from the same manufacturer and the same type of rounds, right?
Yes, they're Hornady brand.
Right, and that's what you would expect if officers are given duty ammunition and duty weapons.
Yes.
You would expect the weapons to be the same, and you would expect the ammunition to be the same.
Yes, that's typically how we receive it.
Right, and so this is not a situation where any one of these officers has chosen to fire like more deadly ammunition than they're supposed to, or any kind of different ammunition. They would all be what you could kind of see as department-issued ammunition that's given to them for their duty weapons.
Everything that I examined seemed consistent with the duty ammunition.
Right, and so, because we talked about hollow point versus full metal jacket, because you had described the hollow point as kind of opening up on impact to something, right?
Yes.
And you know that one of the reasons that police officers use hollow points, one of the reasons is that full metal jacket rounds can sometimes travel and keep going through other walls and could possibly injure other people.
Yes.
And the reason that they would use a hollow point, because I think a lot of people may think that hollow point is just for stopping power, but really what the hollow point and why police officers need to use it, one of the important reasons is so that the bullet will slow down and will not keep traveling through to other places, like other apartments or other places around there. You would agree with that?
Yes.
Yeah, so it's part safety that they would use hollow points, because they don't want a bullet to go somewhere they don't want it to go and hurt somebody that they're not intending to hurt.
That may be a reason.
Right, okay. So because you did your examination September 14th, and you submitted your report. When you submit your report, is that when you give it to the SAPD, or you give it to the prosecutor? Who would you give it to?
It depends on the case. That date is when the report is issued. So that's after I've done all my examination, all of the peer review has been complete. Depending on the type of case, if it's one where the report is requested by a detective or prosecution right away, then there are times where we may send it to them. But otherwise, I think it just goes through our system and they distribute it. Our office distributes the reports.
Sure, and I guess my point of that is that you're not, it didn't go out to the public, it goes out to law enforcement agency and perhaps the DA's office.
Yes.
Yeah, so as far as, because it seems like, after going through all the bags and all the stuff and everything else, it seems like what I got from that is that there was one bullet that was recovered from the medical examiner's office, that you got from the medical examiner's office, right?
Yes.
And you understood that to be recovered from the body of Melissa Perez?
Yes.
Okay, and you were able to match that one, you said, to Sergeant Flores' gun?
Yes.
And, I want to be clear, all three of these officers were justified in what they did based on the evidence we've seen, but you weren't able to match any other bullet that was inside of her or that had gone through her to any of the other officers.
As far as the trajectory of, or the path that the other bullets took, I don't know if any of the other bullets could have impacted her, or if they just hit various objects.
Right. And so and I guess what you're saying by that is there was only one that you could say matched a gun that was inside of her body that had hit her.
Yes.
Right. So, and of course, that is no determination on whether or not Sergeant Flores was justified or was confronted with a deadly threat, because you don't make those determinations.
I don't.
Right. And as far as the other two, your findings, you would agree, your findings were not made or given to the police department or to any law enforcement agency until September 14th or after.
That is when my reports were completed.
Right. And I guess, and I'm just trying to figure out, because I don't know. It wasn't maybe August 14th that you called them and said, hey, I haven't done my report yet, but these are my findings.
No. No.
Can you tell when you got the items for the September 14th report?
When I got the items, I believe my notes say when I initially started working on the evidence. That looks to be September 8th, 2023.
So September 8th, 2023 was when you first started working on them, and you would assume that that's probably pretty soon to the time that you received the items.
Yes, so the packaging that I had looked at has the date that I essentially would have opened it to start working on it.
Okay. And is it common that like it would sit around for a couple of weeks before you open it up, or is it your practice that, once you receive the evidence, you open it pretty quickly in time?
It really just depends. I tend to receive a lot of evidence, and it doesn't always get worked immediately.
And so and you've dealt a lot with firearms, and I think the way that you do your comparison, I saw on my field trip there, that you have a microscope that basically you can look into like this, while putting two separate projectiles, I guess what you're trying to compare in this case, bullets, on two separate like trays or something, and then what you have here kind of puts those two side by side so that you can see it microscopically.
Yes, so the image, if you were looking through the eyepieces, there would be a vertical dividing line, and on one side would be one stage, the bullet you put, and then the other side would be the other bullet, for example.
And as a forensic scientist, you would call yourself a forensic scientist.
Yes.
And as a forensic scientist, your work is necessary and important in trying to determine and discover what the evidence is telling us about what happened. You would agree with that?
Yes.
Right. And so in your particular case, you're trying to match tool marks to a firearm, or sometimes, for instance, tool marks aren't just guns. It could be like if you used a hammer to pry open a door, you could try to match tool mark that way.
Yes, I could.
Right. If you used a hammer or some pry bar to pry open another piece of metal, when that metal goes on metal, it would make a tool mark that you could potentially analyze to see if it matched.
Yes, that is a type of work we can do with other tools besides firearms.
Sure. And in this case, though, you were never given a hammer to analyze, and you were never given or shown like a door that could have been pried with that hammer, or an alarm box that could have been pried with that hammer.
No.
If you had been given that, you would have done your best to try to see if that matched up.
If that were submitted and that were the request.
Right.
Yes.
And perhaps if you could say, because there's sometimes that you can't make a match. Like apparently in this case, there were bullets that you just said, look, they're fragments. I can't even, I don't have any tool marks on them that I can compare it to. So, do your reference sample, things like that. And that happens often.
I had the 3 little lead fragments, but everything else I was able to find a source for.
Sure, in this case, but I'm just talking about in cases in general. You have bullets that are they're mush beyond recognition. There's just not enough characteristics that you can look at to see, and it just sometimes you won't be able to make the comparison, right?
Correct. Yes, there can be damage or other factors that. Essentially, there wouldn't always be enough data for me to make that determination.
Sure, but if we talk about a hammer and we talk about maybe different things that it could have pried open, if those were submitted to you and you looked at it, you may not be able to find a match, but you may be able to find a match, a tool mark match.
Yeah, that's possible.
Or you may be able to exclude the hammer and say the hammer did not cause this pry, there's something else or some other object or tool or weapon that caused this damage, right?
Yes.
Right. But none of that was submitted to you.
No.
Okay. So. Yeah. So just so we're clear, what I'm talking about is like tool marks. And tool marks means anything where two things are going up against each other. And making certain marks, you can forensically and microscopically analyze those things to see if they could have come from this tool, whatever that is.
Yes, so the harder of two objects would be the tool, and then the softer would leave a tool mark. So-
Right. And so, and that, like I said, I mean, I've said hammer, but, I guess you could do like a bat, a bat beaten into a door or something. If the door was soft and the bat left certain marks and it matched up, I mean, you could do something like that if you were asked to.
Yes, there's various objects that could be looked at.
I mean, saws, if a saw was used and, the saw would be the harder and it'd be the tool, and then it would leave a certain mark that you could microscopically analyze and see if that saw made that cut.
Yes.
All right. Knives, any of those things. So it's not just firearms, it's firearms and tool marks, really.
Yes.
Right. So, and I make that point to say that if you could rule out that a hammer caused this, then the implication would be, well, some other tool that we don't have must have caused whatever damage this is. Do you see what I mean?
Possibly, yes.
Right. So, and so we're talking about September 8th, you're working on it, and I'll just say, I've always thought you do a good job. You're a good forensic examiner. And you get this stuff September 8th, maybe start working on it, maybe you get it before, but you start working on the 8th, your report comes in by the 14th. And this incident occurred on June 23rd, which would have been September, over 2.5 months before you did your examination.
Yes.
All right. And you would agree that your examination is an important part of an investigation, typically criminal investigations, to either determine or rule out what happened in these scenarios.
Yes.
Right. So, you also, I don't know if you know, but Ms. Perez was shot twice. We had a medical examiner yesterday testify that it is impossible if somebody is shot twice. The only possibilities are one person shot her twice or two people shot her once. But it is impossible that three people shot her once. Does that make sense to you? If there's only two bullet holes.
Okay.
All right, so all three of these men were arrested for murder on June 23rd, 2023. And you would agree that that is 2.5 months before you're even able to do this analysis to figure out which of these guns actually shot the person.
So to be clear, the evidence did come into our lab on July 3rd, 2023.
So it came in on July 3rd. So they're arrested for murder June 23rd, 2023, like 16 hours after the incident. And even though it came in on July 3rd, you didn't, no fault of yours, but you didn't do the analysis to be able to tell the police department and to tell the people that arrested them for murder exactly what your findings were. Those findings had not been made by the time that they were arrested on June 23rd, right?
Correct, my findings were September 14th.
Right, and so, you see what I mean? And usually, you would agree that you would do your work and then make your findings, and then there would be, that's part of the investigation of any kind of offense. That would be the normal part.
I mean, that isn't my determination.
But it would be an important, because I'm going to say you are an important part of these investigations, and I think that you would agree that you're an important part, because when you're talking about an officer-involved shooting, you're trying to figure out which bullet came from which gun, right?
Correct. This timeline is pretty fast for us in our laboratory.
Sure.
We do have 1 to 2 year backlog currently, so.
But they told you that this was important and that you needed to rush it, I guess. Is that why it got fast?
I think so.
Yep. And so but regardless, you were willing to, because you're one supervisor, or maybe the supervisor now. Okay.
Yes.
And congratulations. I don't know if you were the last time I talked to you, but congrats. As the supervisor, you were willing to say, yeah, I mean, I don't worry about the backlog. I'll rush it to make sure that we get it right. I'll rush it to make sure I can get the findings for you as soon as possible.
Yes, I was not supervisor for that initial part, but
Understood.
for the other ones I was.
And obviously somebody agreed that like, yeah, okay, you want it done quicker, we'll do it quicker, right?
Yes.
But still, they arrested them for murder on the day that it happened before you could do your findings. You agree with that as well?
Yes, if that's the dates, then.
I'll pass it.
The judge? Yes.
Do you mind taking the
Microphone.
It's pretty loud, I probably.
Yeah.
Ms. Warden, you talked about finding some lead fragments. What, in your opinion, were lead fragments?
Yes.
Okay, you can't testify to a scientific certainty those were lead fragments, correct?
That's just my opinion that they were lead fragments.
I mean, you didn't conduct any chemical testing to prove they were lead fragments, correct?
No.
Okay. And if the evidence shows that in that, what Mr. Dawson was talking about, that fire alarm system, the backup batteries contain lead in those backup batteries for that fire alarm system. Okay? And if the evidence shows that there were at least 13 of those batteries inside that apartment, could that account for some of the lead you found?
I'm sorry, you were saying batteries?
Yes, backup batteries for a fire alarm system.
Oh,
Do you know, are you aware they contain lead? Lead plating and coating?
no.
Okay, and when they get old or damaged, the lead can slough off and resemble what I guess you're saying are bullet fragments, is that correct?
I mean, I don't know anything about batteries or what that would look like to be able to compare it.
All right. So if the batteries had been recovered and taken into evidence by SAPD, you could have tested the lead in those batteries against what you found, the evidence that was submitted to you. Would that be fair to say?
I don't think that's a likely scenario, just because we don't do chemical, analysis of lead in that way, so.
Okay. But would another section of the Bexar County Criminal Investigative Laboratory be where they could do that?
That I don't know.
Okay. Well, I mean, y'all have GC testing. You have all sorts of equipment and testing. You have a full panoply of forensic scientists at your disposal at that Bexar County Crime Lab. Wouldn't that be fair to say?
There are different sections that do different types of testing.
Okay. Thank you, ma'am. I appreciate it.
Your Honor, I'll be brief. Is it okay if I stand by the witness?
Yes.
Okay. I'm not going to rehash everything that's been covered. My name is Christian Newman. I represent Mr. Flores along with Mr. Nisbet. I just want to hit some timeline things real quick with you, because I got a little confused because there's a bunch of different submissions that happened here, right?
Yes.
And we can tell by the litany of bags that there's things that maybe went to multiple places even at the lab, right?
Yes.
And so on that note, you're not part of the DNA section, right?
I'm not.
Okay. But if there's testing, multiple types of testing that need to be done on an item like a projectile, they should go in a particular order, correct?
Yes.
And so if we're talking about DNA and firearms and tool mark happening on a projectile, what's the order that things should happen with something like that?
It would go to the DNA section first, because typically when we receive bullets, we will clean them and remove any biological material.
Okay. And when you receive evidence at the lab, there's these evidence submission forms that are submitted, right?
Yes.
Okay. And so they have the relevant information so that you can keep track of items, right?
Yes.
And make sure we maintain the integrity of the chain of custody, right?
Correct.
Okay. And on those forms, there's things like the name of the investigator on the case, right?
Yes.
So in this case, it'd be Ronald Soto.
Yes.
It'd be the alleged offense date for the case, right?
Yes.
As well as a list of the items of evidence that need to be looked at or being requested to be looked at, right?
Yes.
And they'll give a description of what it is they want done, right?
Yes.
And if it's not asked for in that form, it's not going to be done, right?
It just depends.
Okay.
There's some things that are just kind of like a default that we will do, but...
So what's an example of that?
Well, like if it just mentioned a firearm, but there was ammunition with it, and they didn't ask to examine the ammunition, we still just would examine it and still report it out because it was with the firearm.
And that's standard practice, and so you'd expect that, and you could maybe assume, well, they didn't quite specify, but we'll go ahead and do it anyway.
Yes.
Okay. And so let's talk about some of the dates. So we've heard that the arrest date was June 23rd of 2023. Is that the offense date that's on the evidence submission forms?
Let me see if I can find mine. I have date of offense June 23rd, 2023.
Okay. And so I don't want to deface states 184 here, so I'm going to use post-its instead. And we'll put arrest date, June 23rd, 2023. And the first submission of those 16 shell casings, I think you told Mr. Goss that happened in July. Was it July 3rd of 2023?
Let's see. So the cartridge cases and the 3 firearms came in July 3rd, 2023 to the laboratory.
Okay. And so that's the first submission to the laboratory, right?
Yes.
Okay. And then the next submission, there's an individual projectile that comes in. Was that September 5th of 2023?
Yes. So the medical examiner bullet came in from San Antonio Police Department on that date.
Okay. And then I think you testified that your first report you completed on September 14th, 2023.
Yes.
Okay. All right. Put that here. And of course, the report will only contain findings for items that have been sent to you and you've been asked to examine, right?
Yes, or if it's items that are packaged with the other items.
Right.
Yes.
Okay. And then there's another submission that happens a year later in September of 2024. Was that the 4 new fragments of suspected projectiles?
Yes, the 4 fired bullets. Let me see if I have the submission form. Well, the date is also on my report that they came into the laboratory on September 12th, 2024.
Okay. So we have our third submission of evidence in this case. And then your second report in this case was September 17th of 2024?
Yes.
Okay, and like you said, pretty fast turnaround for the lab, but of course, very important case from the prosecuting authorities.
Yes, I believe we were asked to expedite that.
And your agency, the lab, will try to accommodate that when the DA's office asks for that. It's reasonable, right?
Yes.
And you work in collaboration with other sections over at the lab, right?
At times, we will need to communicate, yes.
Especially when we're talking about projectiles and fragments that may need both DNA and firearms testing, right?
Yes.
And did you interact with Garen Foster in the DNA section in this case?
Yes.
Okay, but there was not any DNA testing talk until September of 2024 in this case, was there?
That, I don't know. I mean...
As far as you know?
As far as I know, no.
Okay, and so if there's email traffic about it, to your knowledge, you're learning about that for the first time in 2024 because you need to know whether you can do testing on projectiles so as not to compromise the integrity of any potential DNA evidence, right?
Correct. So typically, if the request had testing for bullets, that would be sorted and sent for DNA analysis first, if that was something that the investigators requested.
Okay. And you're aware that some of these projectiles, or at least one of them, the DA's office had to pull teeth to get someone to go and pull it out of a wall. It's part of the communication you have with the DA's office, right?
I don't know all those details.
Okay. Well, let me show you something here. As part of the discovery information that your agency compiles for the DA's office as part of the case, you also turn over email traffic, right?
Yes.
And would seeing some emails that you were part of, just to refresh your memory, help you see if you remember something like that?
Yes, it would.
Okay. So if you can look here and see if you remember any discussion of teeth pulling to try and go get some evidence a year and a half later.
Yes, so I do see, if I were to quote, pulling teeth was a term used by Jeff Mulliner in an email.
And he was one of the prosecutors on this case at one time?
Yes.
Okay. And I want to shift gears very quickly, and then I'll be done. You mentioned, I think, something, is it called distance to fire testing?
So muzzle to target distance determination is a type of testing that we sometimes do. And essentially when we do it, we are evaluating the distance the muzzle of a firearm may be from the target that it struck. And that would be by analyzing things like the various gunshot residues that are left on, say, a piece of clothing. So that's one of the only times we'll do a type of chemical test is to test for partially burnt gunpowder and vaporous lead residues that might be left on clothing from that discharge with the bullet.
And that's testing you would only engage in if it was requested of you, of course.
Yes, and then they would have to submit various things such as the clothing.
They being the investigators in the case, the agency?
Yes, the
Okay.
agencies.
And so, to be clear, in this case, on this first submission here in July of 2023, no request for that distance testing, right?
Correct.
And then in September of 2023, when the next evidence submission happens for the firearm section, no request for testing on distance either, right?
Correct.
And then the third submission in September of 2024, another year later, likewise, no request for that distance testing.
Correct.
Okay. Thank you so much for your time. I appreciate it. I'll pass the witness.
May this witness be excused?
Yes, you're excused. All right, state, you can call your next witness.
Your Honor, the state will call Detective Deanna Platt.
Approach.
Yes, yes.
Here, please, Mr. Goss.
Thank you.
Thank you. Sure.
All right, I'm gonna swear you in, okay?
Yes.
Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you may need to adjust the microphone, make sure everybody can hear you.
Okay.
Can you introduce yourself to the jury and spell your name for the court reporter, please?
Deanna Platt, DeannaPlatt.
All right, state.
And ma'am, how long have you been an officer with San Antonio Police Department?
This is my 13th year.
And how long have you been a detective with San Antonio Police Department?
Since 2019, 6 years.
And how long after you became a detective, what's your current assignment?
I work in the homicide unit
Okay, how long have you been a homicide detective?
since I promoted in 2019.
Approximately how many homicides have you been the primary lead investigator on since you've been in homicide?
About 10 to 12 a year, so maybe 40 cases.
Okay. And over your 19, approximately 6 years in homicide, have you also worked or been a lead investigator for officer-involved shootings?
Yes, I have.
If you could please explain to the jury just some of the steps when a, lack of a better word, conventional homicide case comes in and you get assigned to it. How is that assignment made? How do you work it up?
Well, in a normal murder case, just when it's not involving a police, because I work in the homicide unit, but the homicide unit is separated into two details. So you have the murder section, and then you have the aggravated assault section that handles everything else. In the murder section, we handle murder cases and we handle officer-involved shooting cases. And so when we respond to a murder case, usually two detectives go out to the scene. And so it'll be your primary detective and then the detective that assists with the case. When you have an officer-involved shooting, you have two detectives that respond the same thing, the primary and the assisting detective, and then any additional detectives that are required based off the number of officers involved. So sometimes it could be, no additional officers called in, or several more detectives called in to assist with the case.
And were you working in that capacity for an officer-involved shooting that occurred on June 23rd of 2023?
For that case in particular, I was not a lead detective or an assisting detective. I was one of the additional detectives that was called in to assist with the case.
Okay. And what were your specific duties when you got called in for this case?
The supervisor asked for me to respond to headquarters, so I never went to the crime scene. They asked me to go to headquarters and set up rooms and wait for officers and detectives to arrive there.
Okay. Did you have any specific duties involving this case from June 23rd, 2023?
I was tasked with interviewing one of the shooting officers.
Okay. And can you identify who that was?
Sergeant Flores.
Okay. What did you do to prepare for the interview with Sergeant Flores?
So the way our office is set up is it's all cubicle, so it's open spaces, basically, no privacy in your cubicle. The sergeant's offices, they all have doors, right? So there's privacy there. So what we do in all officer-involved shooting cases is whoever the shooting officer is and the officer who's assigned to sit with them waits with them inside of a sergeant office with the door closed, so this way they have privacy.
Okay. And
so I was tasked with setting up those offices.
all right. Any needs they had, they would relay to you and you would try to facilitate them?
Yes.
Okay. When an officer, both an officer who's acting in the officer-involved shooting or witness officers, what else happens once they get back to public safety headquarters? To your knowledge, what is the first thing? The officers were body cameras.
So the body cameras, the sergeants generally take the body cameras from the officers that are involved and they get docked, so this way then they can be downloaded right away for viewing.
And that docking process takes the mechanical camera they wear on their uniforms. It's put onto some type of stand, and then the contents, the video, is downloaded into the computers and the servers within the department.
Right, there's a whole docking station on the wall. Each camera is placed in the docking station, and then it's automatically uploaded to our system, which is Axon or evidence.com.
Right? And then by going over, and what type of arrangements have to be made such that any officer or the officer whose camera was, what has to happen to enable them to view the footage that their camera had recorded? What has to happen?
So typically an officer can view their own body-worn camera video. In officer-involved shootings, those videos are restricted for members of the shooting team, which is homicide. Homicide detectives can view those. And so one of us, when we set up the offices, we also sign on to the computer and sign on to Axon to give them access to view the video.
Okay. And did you follow those steps to make the body-worn camera video available to Sergeant Flores that day?
Yes, I did.
Now, routinely, if I were just a patrol officer, whose body-worn camera could I see?
A patrol officer, I believe a patrol officer only views his own body-worn camera.
Okay.
If depending on the rank, I mean, he can't view mine, he can't view anybody else's, his own.
All right. But a sergeant or a supervisor, do we have greater access?
A sergeant or supervisor does, yes, in other cases.
Okay. To your knowledge, were there any restrictions once you set up the system and signed on for Sergeant Flores?
The body-worn camera team or sergeant restricts access to those videos as soon as possible, and for the purpose of no one else in the department being able to view those videos other than the shooting team.
Okay. But you made Sergeant Flores' video available to him?
So when I signed on, every video, when I sign on to a computer with Axon, every video that's a part of the shooting team, my access gives him access to view it. So when I signed in, he could view any video that was available.
Okay. And the video, we're talking video that responds to SAPD case number 23137586?
If I may refer to my statement and the written statement, because I don't have the case number memorized.
Now approach the witness, Sharon.
Yes.
Detective, I'm showing you what has been marked as State's Exhibits numbers 188 and 189 for identification. Do you recognize State's 188 for identification?
Yes, that is my investigative supplement.
Okay. And what is 189 for identification?
This is Sergeant Flores' written statement.
And do both 188 and 189 for identification appear to be complete and accurate to the best of your recollection?
Yes, they do.
Please feel free to use those as you need to refresh your memory and support your testimony. All that verbiage, I forgot my last question.
The case number was 23137586.
Okay. What was your role in taking, first off, did Sergeant Flores give you a statement?
Yes, he did give a statement.
Tell me how the statement came about. Did you sign on to Axon and you watched it together? What happened?
So in this case and with every other officer-involved case that I've worked, I sign on to Axon. I put the video first of all, the officer's personal body camera video, I put that on the screen for them to view. I walk out of the room so that they can view the video as many times as they want to, as slowly as they want to, whatever they need. They view the video in privacy.
Okay. And how do you know when to go in to start assisting and taking the statement?
They let me know when they're ready, and they will also let me know if they need me to navigate through Axon, because officers typically don't know how to navigate through to view someone else's body camera. So they will come get me to ask to see a video from a different angle.
All right. Did you get called in to assist with any navigation at all?
No.
So when the first time you were called in or notified, is that when you started to prepare or take down the statement?
From what I remember, yes. The first time they called me in there, yes.
Okay. So when you went in, please tell the jury, what was the process? What steps did you follow?
Well, like I said, with all officer-involved cases, I do the same thing. I explain to the officer that this statement, it is their written statement. The only thing that I'm doing is I'm typing it. And so it's all in their words. I do not ask many questions other than and then, and explain to them, speak as slow as I can type and stop, and then, so that's typical, they'll say something and then when I'm finished, and then. And the clarifying questions that I usually will ask is maybe, where were you standing, or how was something pointed, or the gun pointed, or maybe distance. But we go through it extremely slowly to get as much detail as possible.
And so you followed that process on this occasion?
Yes.
Had you yourself seen any video related to this case when you were taking Sergeant Flores' statement?
I didn't view any video in this case.
From the statement you took, how is it that Sergeant Flores came to be at the scene where the officer-involved shooting took place? What brought him there?
Well, I'll refer to my statement, to his typed statement. So he said in his typed statement that Officer Salinas called him to inform him that other officers were going to attempt to make an arrest due to a felony amount of criminal mischief.
Okay.
I'm going to object to this until the statement is introduced into evidence. And if they want to introduce his statement, signed statement into evidence, we don't have an objection to it. But to ask questions about it is hearsay at this point.
Response?
At this point, Your Honor, it is admission by a party opponent. It's voluntary. I'm simply questioning the witness to it.
All right, I'll overrule.
Well, we asked that the written statement be introduced into evidence. She's reading from the written statement.
All right, I'll just instruct the witness, and you're welcome to use whatever statement to refresh your memory beyond that. It's not something you should read.
Yes.
So if you would just review it and question it.
And we would ask, under the rule of optional completeness, that the written statement be introduced at this time, since they've alluded to the written statement and his actual statement. So, under the rule of optional completeness, the written statement should be introduced.
Response?
Your Honor, there's nothing that's happened under the rule of optional completeness. There is no misimpression that has been left. I'd like to finish my direct.
All right, I'll overrule the objection, and counsel will have the ability to cross.
You were saying that.
Okay, so per his statement, without reading from the statement, he said that Officer Salinas had called him and told him of a felony criminal mischief that had occurred and that they wanted to make an arrest, and he responded to the scene.
All right. And from what you can recall from Sergeant Flores' statement, were they able to make that arrest, or did something else happen?
And so, just to be clear,
Judge, I want to note for the record that the witness looked at her written statement and that there was a hesitation of 15 seconds or more. And I think that under Rule 106, Texas Rule of Evidence, that it's incumbent that the court permit us to introduce his statement at this time. There's no requirement that the statement or the testimony be unimpeached or vagueness or whatever the case. It says that the party introduces all or part of the writing or recorded statement of that first party may introduce at that time any other part or any other writing or recorded statement that in fairness ought to be considered at the same time. And since she's hesitating about what she remembers, I think fairness requires that the written statement be introduced.
I mean, usually they want the statement in, we want it in, so I don't know why they're stopping us. I'm saying to get the statement, no one's afraid of it over here. Why don't we just enter it into evidence and then she can just talk from whatever's in evidence?
And
Or we can do it on cross, either one. Sorry.
just, as counsel is laid, in my understanding, I'm only asking her what she recalls from what she witnessed, but in the interest of expediency, Judge, I would, may I have states 182?
189.
Thank you. Yeah, states 189. This is a full, complete, accurate copy of the statement of Sergeant Flores you took on June 23rd, 2023.
it is.
Tender states 189 for identification to defense for inspection. Move to introduce 189 in evidence.
No objection from Defendant Eleazar?
No objection. No objection, sir. All right, it's admitted.
So I believe the last question I'd ask you, what caused Sergeant Flores to move to the apartments at 6200 Old Pearsall?
Okay, so just to be clear, you don't want me to read the statement, or should I be reading the statement? I'm not sure. Okay, so he says that when he had arrived at the apartment complex, Officer Salinas advised him the female suspect assaulted him with a candle in a glass jar while the officers were attempting to make the arrest. He saw visible injuries on Officer Salinas' forearm as a result of being struck with the glass candle. Officer Salinas told him the suspect had a hammer in her possession.
And then in the next paragraph, it talks that he approaches the apartment.
So as he walked toward the back patio of the suspect's apartment with Officer Salinas, other officers updated him and said the suspect placed the hammer down on the couch inside of her residence. To the left side of the patio, there was a large window that was open. There was no screen on the window, and he was able to see directly inside the apartment. To the right side of the patio, directly next to the window, there was a glass door with no shades or curtains. Due to having an unobstructed view, he was able to observe the female suspect. He observed the hammer on the couch and recognized that she no longer was in possession of the hammer at that moment. The female suspect was yelling and acting irate. He asked the suspect if she was going to cooperate and come outside her apartment, but she would not comply. He began coordinating with officers on scene to determine the plan of action to take to apprehend the suspect. Officer Alejandro was designated as the contact officer to communicate with the suspect. Officer Villalobos and Sergeant Rivera were armed with less lethal weapons, one with a taser and one with a shotgun with beanbag rounds, and he had his duty-issued weapon.
All right. And from what he put in his statement,
Judge. Ms. Meyer.
I'm sorry, I'm hearing the conversation coming from this way and I can't focus this way.
Okay. All right. If you get a little closer to the mic, ma'am, if you don't mind. Thank you for letting me know, ma'am.
I believe you left off with,
The last
yeah,
paragraph.
the last paragraph.
Officer Villalobos told me the patio door, told Sergeant Flores the patio door was unlocked. The plan was for Officer Villalobos and Sergeant Flores to enter the patio by climbing over the patio fence. Sergeant Rivera was positioned behind the patio to provide non-lethal cover. Officer Villalobos was the first to cross over the patio fence into the suspect's patio. Sergeant Flores saw Officer Villalobos remove the taser from the holster once he was on the patio. He began to cross over the patio fence and heard gunshots. Sergeant Flores perceived the gunshots as Sergeant Rivera firing the beanbag rounds at the suspect. He then saw the suspect walk away from them towards the couch where he had previously observed the hammer to be located. As she was walking towards the couch, it appeared that the beanbag rounds did not strike the female suspect.
Okay, turning to the second page. Turned it on my copy and forgot yours.
The female suspect was yelling, but he did not recall what she said. The suspect turned around and rapidly walked towards them. She had a hammer in her right hand raised in the air above her head as if she was going to attack them. The hammer that she was holding appeared much larger than a standard size hammer, as the tail of the hammer was longer than normal. As she rushed towards them with the hammer raised above her head, he believed the suspect was going to attack them with the hammer.
Judge, I'm going to object to this witness misreading the statement. She's putting everything in third person, and that diminishes that Sergeant Flores is saying in first person what he perceived the fear to be. I would ask that the jury be instructed that this witness has misread the testimony, the written statement, and that it should be read in the first person so that way the jurors understand Alfred Flores' actual fear. If the state is allowed to get away with this, then we're not presenting the full picture of the actual fear.
Your Honor, I note that the written statement itself has been published to the jury, who can also read it along with the witness's words. The jurors can infer, can read and see for themselves Defendant Flores' fear, etc.
And I object to the fact that the witness is deliberately misstating the record and counsel is permitting it to happen and sponsoring the misstatement of evidence.
All right, so just for the benefit of the record, the jurors do have individual screens where this document is being displayed. And so they're able to read along with this witness. Overrule the objection.
Do you want me to read in first person from here on out?
You can just answer whatever questions the state is asking.
Okay. I don't remember exactly where I left off, but as she rushed towards us with the hammer raised above her head, I believed the suspect was going to attack us with the hammer. I unholstered my duty weapon and discharged it in the direction of the suspect, as I feared for the life and safety of myself and the other officers. I gave the female suspect commands to back up as she rapidly walked towards us with the hammer raised above her head. I observed the suspect fall near the patio door inside of the apartment. Officers assessed the suspect for injuries and began performing life-saving measures. Officers requested EMS to the scene. I was sequestered from other officers and I was transported to the homicide office by Officer Rubio, West Patrol Dog Watch, WPC, to provide a statement. When I arrived at headquarters, CSI conducted a GSR test on me and downloaded my ammunition. I consulted with Cleat Attorney Longoria and then spoke with Detective Platt about the incident. Everything I have said to Detective D. Platt, badge 2026, is the truth, and I have read my statement and it is correct. I was not promised anything for my statement, and I have given this statement freely and voluntarily. This statement occurred in San Antonio, Texas, San Antonio, Bexar County, Texas.
Now, and from the document, approximately what time did Lieutenant Flores give you his written statement?
On the document, it says 8:35 a.m., January 23rd. That's in the header.
And let's see, what's the date and time?
June 23rd, 2023, 8:35 a.m.
And prior to his calling you back in, said he was ready to give a statement, did he ask for any breaks, any counseling, any emotional support?
I don't remember if he asked for any breaks.
Did he appear to be calm and focused as he was dictating to you what you typed?
Yes.
Did he make any mention about his being aware of any other people inside the apartment where the woman was?
No, he didn't.
Did he make any mention about talking to the facilities manager for the apartment complex and asking him for a key to the apartment?
No, he didn't.
Did he make any mention about talking to the facility manager?
Judge, I'm sorry, Carol, this is leading, he can ask her open-ended questions, he leading, ask her what he told her, and he said what he said, it didn't say what he didn't say, Judge.
I'll sustain.
All right. Does his statement explain what? From reading the statement, do you know why he decided to go in at the time he went in?
Object to speculation, Judge.
I asked him.
Overrule.
From reviewing states 189. Does it indicate why Sergeant Flores decided to execute what he did?
Can I look at the statement and not read it out loud?
Surely.
So it seems, as per the statement, that he was there for an assault of a peace officer, essentially is what he's saying, because Officer Salinas was hit in the arm with a candle. And so when they went over to the window, to the porch area, that's when they observed the hammer on the couch.
Does it indicate how long he'd been on the ground before he executed his plan?
No.
Who did he believe were firing the gunshots he heard?
He said Sergeant Rivera.
Did he consider asking for any additional resources?
Objection, vagueness.
I'll sustain.
Did he consider asking for officers from the mental health unit?
Not that was typed in.
I'll sustain the leading.
Did he say that he considered asking for officers from the mental health unit?
No, he
Judge,
didn't.
it's the same objection, Judge. She doesn't know, obviously. I mean, he's leading the witness. He just asked her, what did he say, and who did he request, and she can answer.
I've asked if he said it in his statement, Your Honor.
Well, you can ask it that way.
Did he say in his statement that he considered bringing in officers from the mental health unit?
No, he didn't.
Did he say in his statement that he initiated communications with Night CID?
That he did?
Yes.
No.
Did he say in his statement that he directed anyone else to communicate with Night CID?
No, he didn't.
Did he say in his statement that he considered calling for SWAT?
No, he didn't.
Does he say in his statement that he considered having Hire or anyone attempt to get a warrant?
No, he didn't.
Does he say in his statement the time lapse between when Officer Salinas was hit in the forearm and when he executed his plan to enter?
No, he didn't.
Was there a point in time you had to move out of the sergeant's office to other places in the homicide division to complete working with Sergeant Fuller's statement?
After I took his statement, because after he views the body camera, I complete the written statement. And then once the statement's done, it's reviewed by the sergeant. And if there's any sort of corrections that are made on the statement or recommendations, then I return it back. And in this case there was, but I don't remember what it was. I know I took the statement over to him so he could view it and let him know, these are the corrections that they would like to make. It's up to you if you want to make those changes. And he asked to view the body-worn camera video again. And so I remember there was an issue with accessing it in the sergeant's office, so I walked him over to my desk and I pulled the video back up for him to view it another time.
And is that the only time he asked? How many times did you make it available to him to view the body camera footage?
That was the second time. I don't know I don't remember the length of time that he had in the beginning to view it, because they can view it for 5 minutes or an hour, and it's as long as they would like to view the camera. So I don't know. We don't document the length of time in the beginning, and then he requested to see it again, and like I said, there was some sort of an issue, so he viewed it a second time.
And that was my question now. If he asked for it, you facilitate.
Yes.
And you have 189 in front of you?
Yes, I do.
Now, that time, 8:35 a.m., is that the time the statement was finished, or is that when it started?
So the time is in the header, and that time is automatically inserted in there based on when you update the header. So it is not at the end of the statement, it is not when you save the statement, it's strictly update of the header. And I know that because this week I looked at it on a different case, so.
So do you recall, did you update the header when you went in to start the statement, or did you update it when you printed it off so it could be signed?
Generally, I do it in the beginning, but I am human and sometimes I make mistakes and I go in and I adjust it at some point when I see that I didn't change the case number.
All right.
So I don't know what time I finished it or started it. I just know that's the time that the header was adjusted.
Okay, and you correct me if I misheard, but I heard you say generally, your general practice is you update the header when you start.
Yes.
And from your recollection, approximately how much time did Sergeant Flores have to view his camera before you went in to start the statement?
Yeah, I have no idea.
You recall what time you got into the public safety headquarters?
No.
Aside from, what was your other involvement with this case?
I interviewed another officer, a patrol officer, and I set up another interview, a sergeant's office for an interview room.
Okay. Who's that other officer you took a statement from?
Officer Neary.
Aside from what you've told the jury today, did you have anything else to do with this case or this investigation?
I did not.
I have no further questions, Your Honor. I will pass the witness.
All right, members of the jury, it's 1:11. I'll give you a lunch break. Let's come back no later than 2:15.
All right, for the jury?
You can see it.
All right, welcome back, members of the jury. Where we last left off, defense? Yes.
Good afternoon, Detective. My name is Nico LaHood. I'm one of the lawyers that represents the officers in this case. I'm going to ask you some questions. You know this is cross-examination, right?
Yes, sir.
Okay, and you've testified before previously?
Yes, sir.
Okay. If you don't understand my question, just please ask me to repeat it, okay?
Yes, sir.
So as a detective, you've been through more training than the average police officer. Is that a fair statement?
Yes, that's
Right?
true.
And some of your training is you're trained for courtroom testimony as well.
I have never received courtroom testimony training.
Okay, but is that getting tips on how to testify?
No,
No one's ever talked to you about that?
no, I've never
Have
been.
you ever done any training in December of 2023, specifically use of force in Texas, the application and investigation of critical incidents?
Yes, with Butch Mancheka.
And you pointed over in the corner. Butch Mancheka, and so you know Butch Mancheka, right?
Yes, I do.
And so he's the one that taught the course, then?
Yes.
And so we're going to go over some of the things that you learned in that course, okay? And as part of our questioning, is that fair?
Okay.
But I want to talk to you about specifically, you did not, I think you testified to this jury that you never went to the crime scene.
Exactly, yes.
Did you ever, the course of this investigation, and I understand the part you played, did you ever learn more about the crime scene and crime scene, I'm not talking about related to them, I'm talking about to Ms. Perez, and we'll get there in a second, to the actual incident scene, and did you view any of the body cams?
I know very little about what happened before. I can tell you what I know. And I viewed no body camera footage or crime scene footage.
Okay, so you have no personal knowledge, evaluation, you didn't do anything to investigate any of the incident scene?
I did not.
Okay. But you have investigated murders,
I have.
so you're very familiar with Chapter 9 of the Penal Code?
I am, but I do refer to it because I do not have it memorized.
Yes, ma'am. No, we all
Yes.
we all do that, and I'll
Yes.
let you do that as well. But in general, Chapter 9 deals with justified use of force.
Yes.
And the different chapters talk about non-deadly versus deadly force. Would you agree with that?
Yes.
And then when we get into 9.33, it talks about defense of a third person as well.
Yes.
And in general, every citizen in Bexar County in Texas has a right not to be a victim,
Yes.
including police officers,
Yes.
including yourself.
Yes.
And also, citizens of Texas have a right to defend a third person to the same degree that they could have defended themselves.
Yes.
So if somebody is trying, may I use you as an example without, I'm not going to go up to you.
Sure.
If someone is trying to strike you, you're allowed to defend yourself from that strike, correct?
Are we talking with a fist?
Hypothetical. A strike
Right,
is
but
a
when you
fist.
say a strike, so I can just defend myself, we're not talking lethal force in your
I
scenario,
love where
right?
you're going with this. You're
I just
ahead of
want to
me.
make sure.
No, you're ahead of me. I love that. Let's talk about a fist first. If someone tries to strike you with a fist, you're allowed to defend yourself from that fist.
Yes.
If someone tries to strike me with a fist, you're allowed to defend me from that strike with a fist.
Yes.
If someone tries to strike you with an object, you're allowed to defend yourself from that object.
Yes.
And then you kind of already got there. Depending on the force that I show you, dictates legally the force you can resist me with.
Yes.
So if I call you a name, not that I would, you can't punch me.
No.
If I punch you, under most circumstances, you cannot hit me with a hammer or shoot me.
Correct.
And I say most circumstances because size differential makes a difference, right?
Yes.
I mean, if somebody's 7'2" and someone's 5'1", that could be deadly force just in and of itself.
Yes.
Because as a detective, you've seen cases where people have been bludgeoned to death, right? Beaten with an object or
Right.
a fist.
I'm trying to think if I've had one or if I've actually seen one person, because most of our cases are shootings or stabbings. So I don't think that I've worked or been
But
a
that
part
doesn't
of
mean they don't
one.
happen.
It doesn't mean that.
And you know legally that anything in its manner of use or intended use can be a deadly object.
Yes.
I mean, like in prison, they don't have guns or knives, but they have toothbrushes and bed hangers, God bless you. And so anything can be used as an object that can cause serious bodily injury or death, right?
Yes.
May I approach, Judge?
Yes.
I won't get the actual hammer because I don't remember where it's at. I'm showing you Defense Exhibit 11 for identification. I mean, this, you would agree, is a hammer?
Yes.
Depending how I use this hammer, I can either put a nail in a piece of wood or I can plow this into someone's head.
Yes.
One of them I won't be prosecuted for, the second one I will.
Yes.
Right, the plowing in the head.
Yes.
And so you would agree that depending how I use this can be a deadly weapon.
Yes.
And this can cause serious bodily injury
Yes.
or death.
Yes.
And would you agree with me that an object like this, it doesn't take much. I'm gonna get this, okay? I'm not gonna do it hard. It doesn't take much to cause serious injury with this.
Yes.
You could tell I wasn't even swinging that hard, right?
Right.
Would you agree that could cause some pain to some folks?
Yes.
And depending on the person and where you hit, this could actually cause death.
Yes.
Even the way I stroke right there.
Yes.
I may use it in a second. And if somebody is exhibiting that type of force against somebody, in our example before that we were using, that would change the game from the level of force you could use to stop me from using that hammer against you. Would you agree with that?
There are many more circumstances, right, than just somebody having a hammer in their hand.
May I approach, Judge?
Yes.
I agree with you. The reasonable belief of apparent danger and is it imminent? Would you agree that overall that is Chapter 9 definition of when you can use force and deadly force?
Yes.
Would you agree that is it reasonable to believe that I could hurt you very seriously with this hammer? Is that reasonable?
Yes, it is.
Is it imminent?
Yes, it is.
At this level, it's imminent.
When you say this level, you mean from where you're standing?
I misspoke. This distance, yes, ma'am.
So from that distance, yes,
It's imminent.
it is imminent
Okay. And
with no obstructions.
Okay, well, let's talk about obstructions, but also distance, right? Because obstruction, this is an obstruction,
Right.
right? So what you're saying, an obstruction, you don't know if this was locked or not, so you still felt that this, well, you went through it before, so you know. But you're saying that this is not enough of an obstruction to say that it's not imminent, it's not immediate?
So depending, I'm definitely very visual, and so I like to
Sure.
picture and note all details,
Yes, ma'am.
right? And so if you're standing back there, and so is there a door, a wall, nothing? Is it just a walkway? Because there is a difference between standing where you are right there, armed with a hammer, and a door or a whole wall, right?
You were also thought about me throwing this hammer at you too, right?
Yes.
At
If you
some
throw
point,
like me, you
and
wouldn't hit.
You don't know if I'm a professional hammer thrower, but I mean, people can throw things and that can be...
Yes, with no obstructions.
Now you mentioned a door. If this was a door in our hypothetical, and it locks from the inside, who controls who unlocks that?
The person on the inside.
That's right. So the person on the inside could quickly unlock it, and I could still be a threat to you, even if there's a door there. Correct?
You can.
Right.
It also again depends on some more things. If you're right or left-handed, which hand you hold the hammer in. Some people cannot function at all with their right hand. So yeah,
But you're asking these questions with the luxury of this not being imminent, because you know I'm not going to hit you with this hammer, right?
So what I'm asking is just specific questions, just so I understand your scenario, so I can answer the best I can because I wasn't there.
So all I'm saying, well, we're not even taking you there yet. We're talking about our example. So at some point, I'm going to come back to our door, to our imaginary door. At some point, I mean, it becomes even more and more imminent, right, as I walk closer.
Come closer.
And you can tell that I have no agitation on my face. Do you think I want to hurt you right now?
Not right now.
Well, I'll never want to hurt you, by the way, but especially not right now. But what I'm saying is, could it make a difference if I'm looking at someone like this? You see the intention in my face? If I'm cussing at you, if I'm coming at you, this is a different type than even this, even though this can still be, and for the record, I'm holding the hammer at my chest level. This could still be a threat. Would you agree with that?
Yes.
Because it doesn't take much. but would this even be more of a threat?
Yes.
And so, you're asking great questions, Detective. All those matter, right? The interaction between somebody, how they're looking at you, their intentionality with their body language. You would agree?
Yes.
I mean, if this is different than this, would you agree?
Yes.
For the record, I made the running movement stance, which probably looks stupid, versus sitting back with my arms crossed. But you're reading my body language, right?
Yes.
All that plays into your assessment.
Correct.
Do you remember training under the Tula rule?
No, I don't remember.
Maybe you heard it as the 21-foot rule.
Yes.
Okay, that's different, right? That's more common.
Yes.
And the 21-foot rule is really a guide that officers are taught that within 21 feet, and it's about a knife typically, within 21 feet, may I stand up, Judge?
Yes.
That it takes roughly, under this rule, it takes 1.5 seconds roughly for an officer to draw their weapon, get their sight on target, and squeeze off a shot before someone within 21 feet can run to them and start stabbing them. Do you remember that?
Yes, when we're trained that in the academy, it's on an open gym mat with no obstructions to show us how quickly somebody can approach you with it and can kill you, essentially.
Can kill you. And you keep bringing up obstructions. And obstruction, I mean, this is an obstruction, technically.
Yes, and so yes, it does matter.
But it's not much of an obstruction.
Right.
I want to make sure the jury understands that the way you're taught that really anything can be an obstruction. It's whether it's a substantial obstruction to stop my attack.
Yes.
Right. This is different obstruction than that, right?
Yes.
That wall behind you, because we know there's a hallway, is a different obstruction than this.
Yes.
And it depends, well, at this distance, everything's a threat. I can throw the hammer, I can throw a knife, or I can shoot you, correct?
Correct.
But I probably can't punch you from here.
Correct.
So you're talking about the totality of the circumstances, right?
Yes.
And that is a phrase that officers are trained in the academy and in your in-service, that an officer considers everything, totality of the circumstances, when they're assessing a situation, especially a use of force situation.
Yes.
And it's also applied to an arrest, totality of the circumstances to arrest, right?
Yes.
So, would you agree with this general statement? That if somebody, since you don't know the scene much, if somebody is shot at by an officer and they still run back at that officer, that would tell you something about that person that's attacking the officer, wouldn't it?
If someone was shot at and they're still running at them.
I'll just give you the scenario.
Yes.
If I come at you and you have 3 officers behind you, I come at you with a hammer and I swing at you, and one of your cover officers shoots at me in defense of you, and I go back and I look at you and I come back at you again, what would that tell you about my intentions?
Well, I still say the obstructions matter because I am
I didn't
looking
bring
at...
an obstruction into my scenario. It sounds like...
Okay, so your scenario, all right, I'm understanding here.
Okay.
So your scenario is 0 walls, nothing, because it's not, so your scenario is not the case here. Your scenario is just no obstructions, somebody with a hammer coming at me. Yes, you're gonna assume that they're gonna attack you. Yes.
I'm going to get to what you wanted to talk about in a second.
Okay.
So under my scenario, I said you have 3 cover officers, and I come at you, all 4 of you, with this hammer. And I swing at you, and one of your cover officers shoots at me in defense of you. That's appropriate, correct?
Yes.
Okay. And I go back to regain my footing, and then I stop, and then I come back at you again. What would you think about my intentions?
Yeah, the way you're demonstrating here that you want to hurt me or the other officers.
But wouldn't you agree that I was just shot at by your cover officer and I'm still coming back at you guys? Would you agree with me that means I'm either really badly want to hurt you or I want you to hurt me? Would you agree with that statement in general?
In general, I wonder what's wrong with you.
I agree with you. Because in general, when people get shot at for any reason, they go for cover. Would you agree with that?
Yes.
They don't want to get shot at. And if somebody is shot at and they still want to come back with the hammer at the person that's shot in that direction, that tells you there's something wrong with me, right?
Yes.
And under that second scenario of me coming back again, in ours, what I'm presenting to you, you and your cover officer would be justified in stopping my attack with this hammer on you guys.
Yes.
Now I want to go talk about what you talked about, because you kept bringing up obstruction. So we're going to use our imaginary door here. So if your officers, your cover officers, thought this door was unlocked, that matters, right?
If they thought it was unlocked, yes.
Because that just means all I have to do is do this, and it's not even a second to stop my attack, right?
With a swinging door, yes.
Any door, this door over here, any door, this is a heavy door, but I mean any door is not much of an obstruction if it's unlocked, right?
Right, if it's unlocked.
Okay. Now, if this door is locked from my side, is it more of an obstruction for you or for me?
It's a little bit of both.
Who's it going to stop more, you or me?
It's going to stop me
Why? Explain that to the jury.
because I can't get inside I can't get through the door.
And if the lock's on my side, I'm in control of unlocking it, correct?
Correct.
And it wouldn't take much. I mean, if it wasn't bolted in, if it's just a lock, it takes not even a second to unlock a door, correct?
Correct.
So when the control is on my side, it's really not much of an obstruction, right?
Right.
And so in that scenario, with the lock on the inside and the attacker controlling the lock, you and your cover officers have to take that into account, knowing that I can come at you when I want to come at you because I'm the one in control of unlocking that door, correct?
Yeah, you're in control of unlocking the door. You're coming this way. You still have to make the motions to open the door. And so, yeah, I mean, there still is an obstruction, but it's not something that's going to take a minute.
That's right.
It is going to slow you down.
Can you stand up, please, Judge? May she stand up?
Yes.
Show me how you would open a door.
With my right
Yeah,
hand.
just like that, right? It's not it doesn't have bolts on it. Just open a door like that. How do you can have a seat, Detective? Thank you. May I approach the witness, Judge?
Yes.
How do you stop a person attacking you with a hammer? And I'm walking slow right now, but if I was running at you, how do you stop someone running at you with a hammer? How do you stop? And I'm not going to run.
If you're an officer, you're asking, or
Well, any citizen of Bexar County. How can a citizen of Bexar County, including an officer, stop someone running at them with a hammer?
any way that they need to.
Anyway, but just think about some ideas. When you say any way that they need to, give me some examples of the detective.
If they're armed in some sort of way and they are coming at you and they're close, yes, then they can shoot, they can stab, they can do whatever they need to
They
do.
can run over
use their
them, they can
hands.
swing a bat at them, they can throw a bomb at them, whatever. I mean, anything they need to do to stop this hammer, correct?
Yes,
And this hammer at different stages, I mean, it's a threat here, correct?
correct.
It's more of a threat as I get closer to you because now I'm in arm range, but even from here, it's a threat.
Yeah, you're within the 21 feet, which is what we go by
Correct.
generally.
And that's an important distance that officers are trained under. Would you agree with that?
Yes.
Now let's talk about something else. Let's talk about, may I approach again, Judge?
Yes.
Let's assume that, let's put an obstruction in front of you, okay?
Okay.
But the obstruction in front of you is a glass window. Is that much of an obstruction to protect you from me?
Well, what does the glass window look like? Because we all know there's different types of windows. So if it's like a giant glass window with none of like the panes, like the, how they have the squares all in the windows, because if you hit something with a glass window with all those wood squares in it, it's not as easy to break as a whole glass window. So what kind of glass window?
Bulletproof glass would be even more protected.
Just because I haven't seen it, so I really don't know.
You've not seen any, did you know that the average apartment complex doesn't have the glass window you're
So
describing?
that's why I'm just asking what type of
Yes,
glass.
ma'am.
Because my glass door has just the blinds in it. So are there blinds in it, or is
Sure.
it just a?
No blinds.
Solid glass.
Just solid glass. That's not much of an obstruction.
It still is an obstruction, but not as much of an obstruction as a solid wall.
Can I throw this hammer through that glass?
You can, and the glass will slow it down. It won't kill you.
But can the glass fragments break and can cut you?
They can shatter, but it's not like I mean, I'm not an expert,
That's fair.
but I can say
I understand. All I'm saying is I can, if there was a glass and I'm not going to hit you, I'll do this.
Yeah.
If there was a glass in front of you, I could swing through that glass and I could still hit you with this hammer, right?
how close am I?
I'm like this close.
We're this close, yes.
Yes, ma'am.
Depending on, yes.
Right.
If it's that close and you hold the hammer and you don't release it, then yes, you could hit through the window.
Correct. And if I release it, it could still hit you too.
It could, and the glass is going to slow it down.
Well, a glass doesn't slow down a bullet.
No, but not a bullet goes way faster than a hammer in a hand.
I understand. Because of the velocity. The size of the bullet, a bullet's not dangerous in and of itself, right?
No.
If I get a bullet.
Not just a bullet.
If I get I wouldn't throw it at you guys, I'll throw it at my guys. If I get a bullet and I throw it at one of our guys over here, it's not going to do anything to him.
No.
Matter of fact, this is more dangerous than a bullet.
Yes, has more weight.
The thing that makes a bullet dangerous is its projectile, right? The velocity coming out of this weapon here, correct?
Yes.
So when I load this weapon, the magazine, I chamber it, and I would take this weapon and I would shoot it at them. The bullet coming out of this is deadly.
Yes.
So what I'm saying, this in and of itself is more dangerous than a bullet.
Yes.
And it doesn't. You don't have to be 7 foot tall to be injured to hurt somebody with a hammer.
Yes.
Would you agree? I mean, Mr. Goss is a big dude. If you swung that hammer at Mr. Goss, you could hurt him pretty badly. You look like a strong woman, but I mean, anybody could.
Right. Possibly.
You could do some
Yes.
damage, right?
Uh-huh.
So I want to direct your attention back to your investigation, or your portion of this. When it comes, you mentioned a shooting team. I want to talk about that second, but before that, all three of these officers behind me, every single one of them cooperated. You know that, right?
Yes.
What will you describe to the jury what a shooting team is?
The shooting team is the officer-involved shooting team, and they respond to officer-involved shootings to investigate the case.
And kind of what Butch had done that in the past, right?
Yes.
You aware of that?
Well, yes, I'm aware of it. I never worked with him.
I understand that. He's a little more seasoned than you. You're a lot younger than Butch. But I mean, he did that for decades, and we're going to hear from him. And they investigate. The shooting team investigates an officer-involved shooting, OIS.
Yes.
And I want to talk to you about an IDR, incident detail report.
Yes.
This is in general. This is not specific. So in general, as a detective, if an officer is dealing with a mental health or a mental decompensation situation, somebody is having a mental health issue, that is usually placed on the IDR, correct?
It's dependent on if the caller knows that.
Well, that's an excellent point. Thank you for bringing that up, Detective. So if you have 3 officers that show up on a scene and previous officers did not put on the IDR that they're dealing with a mental health situation, there's no way for them to know.
Well, previous officers don't necessarily put it on there. It can be dispatched that way because that's part of one of the dispatched calls.
But what if you weren't dispatched for that and it happened when the first officer came to the scene? The dispatch wouldn't even know that it's appropriate because officers are called out by the original officer, not by dispatch, right?
Oh, I don't know those details.
I guess my point being is the original officer that's dealing with a mental health situation has to notify dispatch for any cover officers to know what they're dealing with when they arrive at a scene, right?
I don't know that. I'm not familiar with that procedure because I've been off patrol since 2019. I don't respond to mental health calls, so I would have to review the general manual myself.
I'm not trying to hold you down to something that you're not privy to, Detective. But how would you investigate a situation or an officer-involved shooting if you're not familiar with the manual or the IDR process or how dispatch works?
How do you investigate an officer-involved shooting?
Yes, ma'am.
Well, there's many times, I wouldn't say many times, but sometimes things happen where you're not familiar with what it is, and part of our job is we're the investigators who respond an hour, 2 hours after the crime happened, and then we have time to actually look stuff up. I like looking stuff up because I want to make sure that what I'm doing is correct.
Yes, ma'am.
And so I would look it up. So if I'm not familiar with the policy that well, first of all, we investigate the criminal part of it, not to the policy. The policy is for internal affairs to investigate, not the homicide
You
investigator.
brought something up that's important in this trial. So policy is
It's not criminal, and that's not what I investigate.
You went quick through that, but it's important to this jury.
Okay.
The government's talking about this a lot. So policy is not the penal code. Would you agree with that?
Yes.
So like for SAPD, there's a policy against chokeholds, right?
Yes.
But other departments don't have that same policy.
I have no idea.
Okay, fair enough. But the penal code doesn't say no chokeholds. I mean, that could be reasonable or unreasonable in using force to defend yourself.
Yes.
SAPD has a policy against vehicle chases.
Yes.
But for sure, BCSO does not have that same policy. So other departments may not have that policy, right?
Right.
And there's nothing about no police chases in the penal code, correct?
Correct.
That may be reasonable, it may be not be reasonable.
Yes.
Depends on the totality of the circumstances.
Yes.
Now, the government asked you about, I guess, Sergeant Flores not mentioning that there was a man in the apartment with Ms. Perez. Do you remember that question?
Yes.
You agree that when these officers are under stress, and even though they have time, they're just, they often don't write every single little detail in those statements, correct?
Yes.
I mean, because we have body cam. I mean, the jury has seen it, by the way, so you don't have to worry about saying anything. The jury has seen many body cams, but not all. And that's what the body cam is for, correct?
Yes.
The statement is just to kind of match the officer involved in the shooting, kind of their mindset. We call it mens rea in the law, right?
Yes.
Their mental intent with the body cam.
Yes.
And back then, they also asked you a question about the mental health unit, because he was asking you all these questions. Are you aware that back then, during the incident, the jury's heard this already, that the mental health unit was not 24/7 at the time? Do you recall that?
Yes, because that's a new change.
It's a newer change, right?
Yes, so that's why I know that.
Yes, ma'am. You're familiar, and I know you don't have it memorized, but we're going to talk about the code. In general, you know that a citizen in Bexar County or in Texas cannot resist an officer for an arrest.
They cannot, yes, they cannot resist.
No matter what.
They cannot resist.
They cannot resist. Even if later on a judge determines that arrest was not authorized, the law says you cannot use force against an officer. You're aware of that, right?
Yes.
And specifically, and I'm going to have you read it, 9.31, right? Specifically B2. Judge, may I approach?
Yes.
And at this time, Judge, I'd like to take judicial notice. We took judicial notice of 9.31, but specifically B2. I think you already did.
Okay.
You mind reading this to yourself?
To myself.
Well, you can read it out loud. I mean, yeah,
Which one am I reading?
right here.
B2.
So, B, the use of force against another is not justified to.
Okay. To resist an arrest or search that the actor knows is being made by a peace officer or by a person acting in a peace officer's presence and at his direction, even though the arrest or search is unlawful.
Stop real quick. So even if the arrest or search could be, when we say unlawful, it doesn't mean they're breaking the law, but meaning unauthorized by law, right?
Yes.
So even if you were to be arresting me, and let's just say later on you were wrong to arrest me, okay? You exceeded your authority to arrest me. The law says that I cannot stop you from arresting me.
Yes.
Right, because we have a remedy for that. If an officer, in our scenario, if you were abusing your authority for whatever reason, and I'm not saying that they didn't do that, all I'm saying is there's a remedy for that, and it's called go before a judge, and it's called a motion to suppress. Have you heard of that term, motion to
Yes.
suppress? A motion to suppress, please tell the jury, is when a citizen believes that an officer overstepped his or her boundaries, and then they hire a lawyer, they file a motion to suppress, they go before a judge, and they make their legal arguments, and the judge says, you know what, detective or officer, you overstepped your bounds, this case is going to be dismissed, this evidence is going to be kicked out. That's the remedy, right?
For resisting.
No,
Yeah.
but what I'm saying is,
Right.
if I believe that you're overstepping your bounds
Uh-huh.
in arresting me or searching me,
Yes,
I have no permission by law to resist you.
right,
I definitely can't use deadly force against you.
right.
Is there anywhere that you remember in the statute where it says, if the suspect believes that the officer is doing something they don't want them to do, as in arrest the person that should be arrested, is there anywhere in the statute where I can use a hammer? David says yes. I'm going to put him on the stand in a little while because he's wrong. But is there anywhere in the statute where it says I can use a hammer against you?
Where you can use a hammer?
Yes, ma'am.
No.
Can I punch you?
If
I believe you're overstepping your bounds, can I punch you?
no,
Can I push you?
no,
Can I throw you?
no.
I can't use any force against you. I have to let it play out in a court of law, correct?
Yes,
And that's a good public policy, would you agree?
yes,
Because we don't want citizens, rightfully or wrongfully, being the judge or the jury and then taking actions in their own hands, right?
right.
We want other people to determine that, and that's a good public policy for safety in the community with our law enforcement and with citizens. Would you agree with that?
Yes.
Detective, thank you for answering my questions. Pass the witness chair.
John Plot, oops. You're Detective Deanna Plot, correct?
Yes, I am.
All right, and you would agree with me that you're required to take TCOL training?
Yes,
And TCOL stands for the Texas Commission on Law Enforcement.
yes,
And you're supposed to, you've taken training on the use of body cameras and how to handle digital media, correct?
yes,
And it originally was enacted in statutes, the Texas Occupation Code 170165, at the time this happened. And it's been recodified in Texas Code of Criminal Procedure, Chapter 2B.106B4, that entitles an officer to review all of the body-worn cameras before he's required to give a statement, correct?
yes,
And Ken Paxton wrote an opinion that says that officers are entitled to review all of the body-worn cameras of an incident, not just their own, but all officers, before they're required to give a statement, correct?
yes,
And so there were 15 body-worn cameras of this officer-involved shooting, correct?
I don't know.
All right. And would you agree that it would take over 15 hours to review all of those body-worn cameras from beginning to end?
I don't know.
Does that sound reasonable from what knowledge you do have of this case, that it would take a minimum of 15 hours to review all the cameras?
I don't know the length of the case or the length of each body camera because everybody arrives on the scene at different times. I really don't know.
All right. So would you agree with me that we can see who reviewed all the body-worn cameras by examining the audit trails?
Yes.
Explain to the jury what the audit trails are.
I'm not an expert in that, but what I can tell you is just basically just when you look something up, it shows which person viewed which video, which camera. It's sort of like your internet history. It tracks the searches you made, so that's the easiest way for me to compare it is under your username, whatever body cameras you viewed are under your name, which creates the audit trail.
All right. And have you reviewed your user audit trail of this particular case?
I did look at it.
All right. And would you agree with me that you did not look at all of the videos of the officers present at the time the shooting happened before you took the statement from Officer Neary and Sergeant Flores?
I definitely did not. I
Okay.
didn't need to. I wasn't the officer giving the statement.
Okay. And I realize that you definitely did not, and you opined that you did not need to do so. But you would agree with me that the totality of the circumstances is something that's taught in the SAPD Use of Force Training Academy about whether force is justified in a particular case, correct?
Yes.
All right. And so you would agree with me that part of totality of the circumstances is dependent upon what crime the suspect has committed, correct?
Yes.
And so were you aware, and if you're not, that's fine, were you aware that there was 3 attempts by Melissa Perez to strike officers in the head with the hammer?
No.
All right. And you agree with me that if there were 3 attempts to strike officers in the head before shots were fired, that the shooting officers would be entitled to take that into account as part of the totality of the circumstances?
Well, I was not the investigating detective.
Ma'am, answer the question. It's either yes or no.
Ask again, please.
Can the court reporter please read it back?
And would you agree with me that if there were attempts to strike officers in the head before shots were fired, that the shooting officers would be entitled to take that into account as part of the totality of the circumstances?
Yes.
All right. And the reason they would be able to take that into account is that striking an officer in the head with a hammer is aggravated assault with a deadly weapon, isn't it?
Yes.
And that's a serious offense. Yes?
Yes.
It's a first-degree felony, yes?
Yes.
And a first-degree felony is punishable by 5 to 99 or life, right?
Yes.
And you would agree that's a serious offense?
Yes.
And Mr. LaHood asked you questions about when someone engages in repeated conduct, that's indicative of intent. You would agree, correct?
Yes.
And were you aware that one of the incidents where Melissa Perez attempted to strike Officer Jonathan Salinas, she swung the hammer twice at approximately 1:40:51 in the morning? Were you
No.
aware of that? I'm sorry?
No.
Okay. And you would agree that that's approximately 22 minutes before the first shots were fired, correct?
No, I don't know the time the calls came out. I
Okay.
have no idea.
You don't know what time the shots were fired?
No, I don't.
Okay. So if you did you look at the body camera at all?
No, I testified that I didn't view the body cameras.
Okay, so you don't know the time shots were fired?
No, I don't.
All right. So if you're going to take a statement from an officer, do you believe that a competent investigator would want to capture the totality of the circumstances before shots were fired? Yes or no?
No.
Okay. So in your mind, the totality of the circumstances is not relevant in a witness statement for an officer who fired shots?
No.
You say it's not important?
Well, you're only letting me answer yes or no, so I have to say no.
Okay. So you don't think that it's important as part of the totality of circumstances. Would you agree that totality of the circumstances determines whether or not an officer acted reasonably?
Yes.
Okay. So you understand that Chapter 9 states that whether force is justified by a police officer when he's using force to make an arrest, that you must put yourself in the shoes of a police officer at that time, of a reasonable police officer at that time, correct?
Yes.
All right. So in order to, have you ever been, you're a detective, correct?
Yes.
Have you ever been trained that an investigator is required to gather all evidence for the jury so the jury can decide what decision to make?
As an investigator?
Yes.
As the lead investigator, yes.
All right. So as an assisting investigator, if you're given a particular component to look at, you're supposed to do a thorough investigation of that component that you're assigned, correct?
Yes.
All right. So if you're given a specific component of an officer's use of force, you would be required to look at all evidence to explain why an officer fired, correct?
No,
You're not? You don't agree with that?
no, I don't.
So how would a jury know whether he considered totality of the circumstances if you don't inquire into it?
There's none of my opinion in this statement, and even in my supplement, there's not. I was an assisting detective, and my goal was strictly to take his statement by his word. That was it.
All right, so in your mind, all right, let me take a look at something. All right, I believe you said that you attended Butch Majeska's use of force in Texas, the application and investigation of critical incidents, correct?
Yes.
You attended that in December of 2023,
I don't remember the date, I just remember I attended it.
and that was at the Kendall County Sheriff's Office,
Yes,
and Butch Majeska was teaching the class.
yes.
And were you sent there by the San Antonio Police Department, or did you go there on your own to pay for it?
I believe I signed up for it on my own and they paid for it.
Okay, so San Antonio Police Department sanctioned your training through Butch Majeska, right?
Yes,
And Butch Majeska, you would agree that he's an expert in the use of force, correct?
I have no idea if he's an expert.
All right.
I know
well,
he's an instructor.
He taught a course in the application and investigation of critical incidents, which includes officer-involved shootings, right?
Yes,
All right. And so, do you remember, that it was a 3-day class? I'm sorry?
I remember it was multiple days.
All right. And do you remember telling Butch Majeska at the conference that you did not look at all of the body-worn cameras because you thought it was unimportant?
So this is a yes or no?
Yes.
That, I don't remember saying that, no, not that specifically.
All right. If we were to hear testimony otherwise, would you deny it?
If I can answer more than yes or no, I can easily explain what I said.
All right. Well, what did you say?
So what I said, or what I believe that because I do not believe in officer-involved shootings or in officer-involved shootings when I'm taking a statement from an officer. I have never viewed the body-worn camera prior to giving a statement, especially as an assisting detective. When I am the lead investigator, yes, I will view everything that's pertinent before making my decision on the case. When I'm an assisting detective, I do not view the video because I am not going to put my opinion or sway anybody in this. I want it to come direct from the officer, what he has to say, and so I'm not going to taint my view, so I do not think that the video should be viewed. It is not in our policy to view the video before we take a statement. So I do not think that it's my responsibility as an assisting detective who did not have the handling responsibility on the case to view that video or any of the videos.
Would it be fair to say that it was someone's responsibility to look at all of the videos, correct?
Yes, not mine.
Okay, and whose responsibility was it to look at all of the videos?
The handling detective,
Who was?
Detective Soto.
And if he did not look at all of the videos before obtaining a warrant, that's not good, is it?
It depends on who he's talking to.
Well, if he was ordered by the chief of police to do it and against his better judgment, he rushed a warrant, he can say it's the chief's fault, right?
I don't know anything about that. I was not part of any of those types of conversations.
All right. So do you know when the decision was made to arrest?
I have no idea. I wasn't part of that.
So would Detective Soto be able to answer that question?
I'm not Detective Soto, so I don't know.
Now, if you did not tell Detective Soto about the totality of the circumstances, who could have told him about the totality of the circumstances of the statements that you took?
I do consult, just like we all do, when we take statements. We get the written statement, we put it on the detective's desk so he can view it, Oftentimes, we talk to the detective handling the case and we let them know what was said. But we're also giving them the hard copy, the actual paper copy. So
So let me
he
ask
has
you this.
access to it.
Let me ask you this. I'm glad you talked about this process. If I understand correctly, the shooting team has a powwow where they brainstorm, correct? Is that what you're describing?
No, because you're implying that it's the whole group. The entire shooting team was not called in for this.
Okay, so when you talk to people, would you consider that brainstorming on this shooting?
Yes, but to say the shooting team
Okay,
is
so
not
let's limit
correct.
it to the people you talked to. Who do you recall talking to?
I only recall talking to Detective Soto. I don't know who else I talked to, and I'm positive I talked to more people.
All right. Did you talk to Detective Soto about when at 1:41:50 or so that Officer Rojas, Jesus Rojas, yelled out, "Watch out, watch out, watch out, watch out, hey." And at that moment, Jonathan Salinas pushed away from the open window, and Melissa Perez at that time was swinging a hammer twice at his head.
How would I know that?
I'm not asking you whether you know it or not. Was it talked about?
I didn't talk about that with anybody. I don't know
So
those details.
Detective Soto never raised that with you at any time on the morning of June 23rd, 2023?
He didn't have a reason to talk to me about that.
All right, so is the answer that he never talked about that time frame and that comment by Melissa Perez at any time with you?
With me, no.
You never talked about that?
With me, no.
All right. Did you ever get information from Captain Van Geffen, who was in charge of homicide on the morning of June 23rd, that happened?
No.
Did you get any information from your command staff that happened at that time?
No.
All right. So would you agree with me, based upon your answers, I'm making an assumption, but I just want to clear it up, that at approximately 1:55, Nathaniel Villalobos attempted to enter into the open part of the window and in fact unlocked one of the deadbolts at 1:51:55. Were you aware of that?
No.
And were you aware that at that time, Melissa Perez came running from the bedroom where the invalid was to the window and swung a hammer at Nathan Villalobos, and she ran that distance in 3 seconds?
No.
Did anyone bring that up to you on the morning of June 23rd, 2023?
No, I have no reason to know that.
All right, and you would agree that if both of those incidents had in fact happened, and I'm telling you that they did, and they're depicted on body camera video, that you would agree that those could be important factors in the totality of the circumstances when officers decided to fire upon Melissa Perez?
They could be.
All right. But because you didn't think it was important or part of your lane, that information was not put into the statement that you took for Alfred, Flores, or Richard Neer.
It's their statements, and I can't put words in their mouths for their statements. They have an attorney present.
I understand.
So I don't put words in their mouths. It's what they tell me happened. I'm not going to say, so I'm not going to add to their statement. I can't do that.
All right.
And if it should be, the attorney should step in. I don't know what to say.
Are you blaming the attorney?
I'm saying it's between the attorney and the officer because we leave the room to give them the opportunity to review their whole statement. They can add or take out whatever they want.
All right.
It's not mine.
I understand where you're coming from, but let me ask you this very simply. If it's depicted in the body camera, you agree that what is depicted in the body camera did in fact happen?
What is in the camera, yes, it does happen.
All right. So if it's depicted in the camera, and if it did happen, then that's part of the totality of the circumstances. You agree?
Yes.
All right. May I approach?
Yes.
Push whips.
Yes.
I'm handing you what's been marked as Defendant's Exhibit 2E. It's the user audit trail of Karen Fox. Do you know who Karen Fox was at the time this happened?
Yes.
All right, can you read what this document says right here where I'm pointing?
No audit trail entries were found for this user. Please contact support.
All right, and would you agree with me that the user audit trail is from the date range of June 23rd, 2023 through August 31st, 2023?
Okay, audit report data range, June 23rd, yes.
Through
Through August 31st,
2023?
yes.
All right. I'm going to show you what's been marked for identification purposes as Defendant's Exhibit 2G. And would you agree that this is the user audit trail for William McManus?
That's what it says, yes.
Okay, can you read what it says there?
It says, no audit trail entries found for this user. Please contact support.
All right, and what is the range?
June 23rd, 2023 to August 31st, 2023.
And would you agree that that document indicates that both 2E and 2G indicate that neither Karen Fox nor Chief McManus ever watched any body-worn camera videos on this case during that time?
I would agree that their audit trail showed that they didn't watch it under their username.
All
They
right.
could have watched it under a different username.
All right. I'm glad you mentioned that. You would agree with me that when you, as an officer, get an assigned login, you give an assigned login and password for your username, correct?
Yes,
And the license for Axon does not permit you to use anyone else's username, correct?
I don't know what the license says.
All right, you would agree that city administrative directives governs the use of computer security, correct?
Yes,
And you would agree that city policy prohibits allowing someone else to use your login to view evidence, correct?
to use your login to view evidence?
Yeah.
Well, we do it all the time in officer-involved shootings.
All right, so would you agree with me that 2A is your user audit trail?
Okay.
And 2B?
Yes,
All right, and in that audit trail, would you agree with me that there is a column where you can enter notes or comments?
there is.
All right, and would you agree with me that nowhere in your user audit trail do you indicate that you allowed anyone to view your videos on this case with your user login?
Correct.
All right. And you were taught in the
the police academy in the TCOL course that then Sergeant Leslie Carrillo taught, that you're required to enter comments when you deviate from standard practice, right?
I don't remember.
Okay, but the instructions that you were given in the academy and per procedure 410 require that if you're going to allow someone else to view videos, you're supposed to, on your login, you're supposed to make a comment that so-and-so reviewed this video for investigative purposes, correct?
I've never done it in officer shootings.
Okay. You would agree with me whether you've done it or not, you're required to do that, right?
If I can see what the policy says, I know that you can deviate from the policy, but I don't know what it says verbatim.
So would you agree with me that there's a maxim in law enforcement that if you don't document, it didn't happen? You've been told that before, haven't you?
I wouldn't just say it's law enforcement. I mean, sure, you could say that.
All right, and you agree that's a good policy or a good maxim? If you don't document, it didn't happen?
Sure.
All right. And one of the things that you can do with body-worn cameras is you can clip videos, correct?
Yes.
And if you clip a video and make a copy of it, you're supposed to make a comment, correct?
You're supposed to make a comment?
A comment if you clipped a video and made a copy of it.
I know now I know it auto-populates it says something about write an explanation, so.
All right. Another question I have about the audit trails and body-worn cameras. You would agree with me that very early on June 23rd, 2023, the homicide unit locked all the videos on this particular case, correct?
I don't know when or who locked it.
All right. Explain to the jury, however, what locked means. What it means to lock out the videos.
Well, like I kind of explained this earlier, that the videos are restricted, but he's calling it locked out. And so the videos in officer-involved shootings are restricted, so this way then any member of the department does not have access to them.
All right. And so you would agree they were locked out in this case?
They were.
All right. And if Richard Neary is present when Vince Gomez is explaining to officers that Melissa Perez came this close to striking Nathaniel Villalobos in the head with the hammer, you would agree that that's something he would be required to tell fellow officers?
I don't know the circumstances. I don't know how much time there was. I don't know, because I'm not him.
All right, well, let me ask you this. You would agree that Procedure 302, not Procedure 302, but Rule 302 of the Rules and Regs, which is in Chapter 200 of the General Manual, requires officers to tell the truth at all times?
Yes.
And one of the things that is so important for an officer is to support a fellow officer in a time of need or danger, and that's in 3.06, correct?
I don't know the exact procedure number.
It's a rule, you would agree, right?
Yes.
And whether you know the rule number, you agree that rule exists, that you're supposed to support a fellow officer in time of danger, correct?
Yes.
And so if someone is capable of killing a fellow officer or has shown a past history of being able to kill another officer, you would expect under 3.02 and 3.06 for that officer to tell his fellow officer she came close to killing someone, right?
Was there time to do so? It's not quite that simple.
Okay, so it's funny that you should mention that, so let's explore that. You would agree with me that in time of danger, things are urgent or time is of the essence, right?
Yes.
And so when a fellow officer says, hey, this person is dangerous, the person listening shouldn't say, well, what do you mean? What's the hypothetical? Was there a door? Was there this? Where is this? No, you don't have that time, do you?
No.
And if you had an officer that asked those questions, well, tell me more, I don't understand, you would think that that officer is not worth much, would you?
There's more to it. That's not a yes or no answer.
Okay. So, an officer can ask endless questions when taking action and being cautious is urgent and that's the essence?
It depends on the scenario. If you have exigent circumstances, that means there's no time. If you do have time and you're able to back off and contain, and you have something more of a barricaded subject, then there is time to communicate.
Okay, so
that's why I said, what are we talking?
We already know from testimony that Miss Melissa Perez did not fit the definition of a barricaded subject because she was engaged in criminal conduct, she was not suicidal, and she was not alone. Are you going to try to tell us that she was a barricaded subject?
I said that there's different scenarios and I was
Answer my
not
question.
there.
Are you going to try to tell us that she was a barricaded subject based upon what you know?
Based upon what I know, I think she could have been, yes.
Okay, but you didn't look at all the videos, so how could you know?
You're asking me based on what I know. Based on what I know, I say yes. I did not look at all the videos.
Okay,
I
so
didn't.
wouldn't the truthful answer be that based upon what you know the answer?
Objection,
Yes.
argumentative, the witness has answered the counsel's question.
She is not. This is cross.
You can rephrase.
All right. Wouldn't you agree that the correct, truthful answer is if you have not looked at all the videos, that you don't know whether she was barricaded or not?
Yes, I do agree.
All right. And would you agree with me that in this case, well, maybe you don't know if you didn't review the evidence, but would you agree with me that when the E-tone went out because Jonathan Salinas said, I have one at gunpoint, she has a hammer?
That is in Sergeant Flores' statement.
All right. So you agree that is properly documented, correct?
No, I didn't review the key card, so I can't say that I know. I'm going by what was in his statement.
All right. So if someone were to I think you were asked about the mental health unit. Do you agree that the mental health unit on this date and time was not on duty? Do you agree with that?
That's not what I said. I said I knew they weren't 24 hours. I have no idea what their previous hours were.
So on June 23rd is what I'm asking about, 2023. You know they were not on duty when this incident happened, correct?
No. I don't know what their hours were. Some of our units, like for instance, Fusion goes till 3 a.m. They are not a 24/7 unit. I don't know what time mental health unit
So
hours were.
if previous officers have testified for the state that they were not on duty at this time, you don't dispute that, do you?
Objection, Your Honor, the witness has answered the question. She said she does not know. For counsel to suggest the answer is misleading and argumentative.
It's not misleading. I just want to know if she wants to dispute it.
All right, I'll sustain.
And you would agree with me that in response to a question about whether or not Sergeant Flores called CID, let's break that down a little bit. CID is staffed with detectives, correct?
detective sergeant and I believe a lieutenant. I don't know if it's every day. I know a lieutenant.
And you would agree with me that a patrol sergeant has the ability to make a call whether to arrest someone or not, correct?
He does.
And so there's no need, either in the law or in SAPD policy, for a patrol sergeant to get approval from CID to make an arrest, correct?
I don't believe so.
All right.
Although it does say for felony apprehension, you have to contact the follow-up unit.
All right, but that's only after an arrest is made, right?
Yes,
So you have to make an arrest first before you contact the follow-up unit, right?
I believe so.
All right. Now, I believe you indicated that you would not want to make a decision to make an arrest until you had all the facts, correct?
If it was my case, yes, I would want all the facts.
All right, and that would include getting Leica measurements if that was critical to how imminent the danger was, correct?
Getting Leica?
The Leica scanner,
Right.
you would want to use the Leica scanner if distance was critical, correct?
If distance was critical.
All right. And approach?
Yes.
If I were to run a distance of approximately 13 feet in less than a second and a half and swing my body and force and strike a window about 3 to 5 feet from your head and you didn't see me coming, would you agree that your life could potentially be in danger?
I didn't see you coming,
Yes.
so then when did I see you?
Your life could be in danger, right? If I were to swing.
Yes, but you said I didn't see you coming.
Right.
So I'm just not sure when I would see you to know that my life was in danger.
I'm asking you to assume that objectively the gods in the sky know that I swung this hammer and was striking the window, and the moment that I struck the window, the back of your head was 3 to 5 feet away from the hammer. You would believe your life was in danger, right?
The back of my head is facing the window? I
Yes.
can't believe my life's in danger if my head is facing the
If you
window.
were
I don't know what the gods think,
All right.
honestly.
All right, but you have no reason to dispute that a person watching that happen could reasonably believe that your life was in danger.
Yes.
All right. And if I struck the window previously, if I swung at the window above a horizontal frame about 3 to 4 inches, but previously I had thrown a candle through the bottom portion of the window without any obstructions and hit somebody in the arm, you know that I would have the ability to throw the hammer below the window as well, correct?
Depending on where you're standing.
All right. And if I threw the hammer through the open part of the window, you would agree there would be no obstruction, correct?
Correct.
And if I were to throw the hammer through the open part of the window at someone's head, that would be also potentially life-threatening, correct?
And how far open was this window?
I'm talking about the person's head being 3 to 5 feet away, correct?
The person's 3 to 5 feet away from the head, from the window, and the window is open. For there to be no obstruction, I need to know more.
All right. So would you agree with me that in a split second, an officer has to make an instantaneous decision?
Yes.
And whether in that split second an officer is correct or incorrect doesn't matter so long as the decision is reasonable, correct?
Say in good faith.
You would agree that all it has to be is to be reasonable, to be lawful, correct? If the officer uses deadly force to defend someone and makes a decision in a split second, his decision has to be reasonable, it doesn't have to be correct.
In that scenario that you gave, yes.
All right, so if he makes a decision, whether he's right or wrong, if he acted reasonably, it's justified under the law, correct?
If he's right or wrong.
As long as he's reasonable, it's lawful.
Objection, Your Honor. Counsel is invading the province of the jury. They are the ultimate finders of fact. She has not been qualified as an expert in the council's asking a question.
It's in the statute.
It invades the province of the jury, Your Honor.
All right, you can rephrase your question.
All right. You know that's what the law says, and that's what you're required to find out when you take a statement, is to find out whether the officer's conduct is reasonable, correct?
Not when you take a statement as just with my role.
All right, when you take a statement, you know that that statement is going to be used before a jury when they decide whether or not it's reasonable, correct?
No, I don't. They're not all presented in front of a jury.
I'm sorry?
All these statements are not, that in officer-involved shootings don't go before juries.
And then why are we here?
I said, not in all officer-involved shootings. Most officers are not indicted.
So you don't know why these officers were indicted, do you?
I do know why they were indicted.
All right. Now, approach the court.
Yes.
Please be seated.
Mr. Newman? Is it 107?
Yes.
No, I didn't get the exhibit.
It's up there too.
Did you put it there?
answer, Judge, is yes, we are waiting on it because.
All right, so back on the record. Yes.
I'm handing you what's been marked for identification purposes as Defendant's Exhibit 107. Do you recognize that document?
Yes.
I'm sorry, we moved my microphone and I need it back. I'm sorry, I thought y'all were gonna do it today. I still need that. Thank you, sir. Go ahead.
What is document 107?
An agreed suspension.
And you agreed to it, correct?
Yes, I did.
And you were given a contemplated indefinite suspension, correct?
Yes.
And what is a contemplated indefinite suspension?
Termination.
All right. And the agreed suspension was modified? You didn't get an indefinite suspension?
No.
What was the length of suspension?
1 day.
All right. And would you agree that when you signed this, you agreed to it?
Yes.
And you agreed to waive any right to appeal this agreed suspension and agreed that no administrative or judicial body shall have power to review this agreed suspension or alter the terms of this agreement?
Yes.
And you agreed with the alleged rule violations, correct?
Yes.
And you agreed with the factual allegations, correct?
Yes.
And so you were accused of failing to follow Procedure 607 and Procedure 707, which deals with crash investigations, correct?
Yes.
And the factual basis for the suspension was that you failed to investigate the collision properly and was untruthful on information you supplied on your accident report as follows, causing significant problems for the drivers involved and eventually requiring corrections to the accident report she prepared. 1, you failed to check all parties involved for warrants, failed to collect any evidence from the crash site, and failed to remain at the scene until all vehicles were removed. 2, Officer Platt is observed on Coban dash camera video allowing a vehicle involved in a public property traffic crash that is not drivable and a traffic hazard to be released to the owner in lieu of impounding the vehicle. Officer Platt is overheard telling the owner of the wrecked vehicle she has to tow the truck if she remains on scene, but then tells him he can remove the truck as he pleases if she is not present, improperly abdicating herself of any responsibility for having the vehicle properly towed, correct?
Yes, that's what it says.
And that was true, correct?
Yes.
Judge, we offered Defendant's Exhibit 107 because the credibility of a witness is inherent into the presentation of a defense. And what this document says is that she has been untruthful and has failed to do what's required by policy and has failed to properly investigate reports. And she has put into issue her belief that she's not required to do a complete investigation. The answers to her questions that it wasn't her job to investigate the totality of the circumstances, that was Detective Soto's. So we think this is relevant to show that her answers were incomplete, inaccurate, and untruthful.
Your Honor, the state objects. Under 608, as counsel has said, he wants to attack the witness credibility for truthfulness. 608A specifically requires testimony by a witness with knowledge. 608B prohibits impeachment with specific instances of conduct, which that document literally is. It is also hearsay. Along with that, I would also add to the court, if you even were to go forward to 609, impeachment, if it were a criminal conviction, you could not use it if it were 10 years old. I note that incident is alleged to have occurred May 10th of 2015. We are now in the end of October of 2025. It is too remote. There is no testimony to support any attack on her credibility. It is a singular, specific instance of conduct which is prohibited by the rules of evidence.
Your Honor, may I respond?
Okay,
Well, 613 says specific instances of conduct come in to show bias and motive. And what I want to remind the court of is this witness went out of her way to say she didn't watch any body cams. That the only thing she knew about this case was what Sergeant Flores had said in his statements. And yet, when she's being cross-examined by Mr. LaHood, just, spontaneously says, oh, well, this, if there's obstructions, like a glass door with wooden panes, if there's a wall, if there's an obstructed window, exactly what we're dealing with here. So I think she has directly put her credibility into issue, and we're allowed under our right to defense for all three of these officers to put this particular witness, and then when she's primed to, oh, I know why they were indicted. So we're certainly entitled to go into her bias and motivation in this particular case with this evidence.
May I respond?
Additionally, Your Honor, Texas Rule of Evidence 406 talks about habit, routine, and practice, and what the state essentially did was talk about her habit and practice and routine when she investigates cases. So what we're allowed to do is to refute that habit, practice, and routine to show that it isn't her habit, practice, and routine to follow certain protocols of investigations because she didn't do it before. And it also shows that she was untruthful. So, it's also permitted under B2 because it's for the purposes of proving absence of mistake or lack of accident. Under B2, absence of mistake and lack of accident, she did a sloppy job in this investigation on purpose and is denying that this was an accident or she's not required to do it. So it's essential for us under B2 for us to be allowed to, in a criminal case, to use it for permitted use.
First, Your Honor, 613B2 specifically relies on a written statement to show a witness's bias or interest. I understand that is the report from the Internal Affairs reviewing the agreed discipline.
It's not from Internal Affairs, it's from the Chief of Police.
It doesn't have to be a written statement either. That's
I'm reading the rule verbatim.
All right, let's let him argue, and then once we're done arguing, then the defense can argue.
Along with...
I'm looking at the rule as well, so.
Yes, sir. Along with, if it were allowed, 613B4 requires the evidence of any bias is not admissible unless the witness is first examined and then fails to admit. As the court heard, she was presented with this from Mr. Cifuentes. She did not deny it. She acknowledged it. I don't believe the criteria laid for impeachment, particularly to get it in front of this jury, has been met.
And, Your Honor, bias and motivation are always relevant and admissible in any trial for purposes of due process and confrontation and the compulsory process clause of the Sixth Amendment.
But not with hearsay, Your Honor. It requires testimony.
And this is not hearsay because she admitted that she engaged in misconduct. She admitted it. And by signing this document, she agrees that it's all true. So if she agrees that it's true, the witness has admitted that this is true. And it can't be hearsay.
At which point then, if she's admitted to it, then there is no confrontation by 613.
What was the suspension for specifically?
For untruthfulness.
That was not. That was not.
Judge, will you examine these documents?
Yes.
That was
It
not.
says that she was untruthful here.
That's in the details. That's not the actual.
If it says that she was untruthful, then she was untruthful. And she agrees that she was untruthful.
state what's your understanding that the suspension was for?
I'm reviewing it right now, Judge. Was it? Scroll back to the top.
So what I'm reading is that it says failed to investigate the collision properly and was untruthful on information she supplied on her accident report as follows. Causing significant problems for the drivers involved and eventually requiring corrections to the accident report she prepared.
Yes, sir. Yes, Your Honor, I'm reading that.
And it has number 1 and number 2.
Yes, Your Honor. And so again, as in the hearing, counsel asked the witness about it. She admitted to it. She did not deny it, as the rule requires in order to confront her in front of this jury.
Am I allowed to explain that?
Yeah, you want to ask the witness so I can hear it from her?
Yes, ma'am. May I have the exhibit?
Yes.
Detective Platt. The incident that's referred to under Defense 107, what is it called up front?
It's called an agreed suspension.
And so an incident occurred, you were charged with violating department policy, correct?
Yes.
And you all agreed, did you admit to it when confronted by your superiors?
Say again?
Did you admit to it, the allegations, when confronted by your superiors?
For the agreed suspension. Now there were a few allegations. I don't remember all of them, but I know untruthfulness was one of them, and the reason why it was not that which made it a contemplated indefinite. The untruthfulness was not founded, and it was dropped to a 1 day. And so the board had agreed that the others, which was, I think, just these two, the part that you're reading was the factual basis for the instant disciplinary suspension as written by the IA sergeant. It says the violation of the policy were from, because you have to have the specific policy listed, and so the violations that were listed that I violated were impounding vehicles from the crash scene and crash investigation responding to crashes. That's what ended up resulting in the 1 day suspension, was those two allegations. The other allegations were not founded, and that was not part of the 1 day suspension.
So, Your Honor, and with that, I simply close again. It's titled agreed, which, just to my common understanding of the word agreed, does not mean she denied, evaded, and/or lied. I say again, it's not permitted, even under the fullest reading of 613, it's not permitted by 608, along with to impeach with, again, a specific instance of conduct. If this were a criminal conviction, it is too remote to be allowed to go before this jury. It should not be allowed to come into this trial.
Your Honor, add one thing here, if I can. Evidence that a person has been untruthful, if she was, evidence of that is not admissible in court. The only thing admissible would be if they called a witness who was going to testify about her character for untruthfulness, or had an opinion about her untruthfulness. They can't come in and testify that, when she was 14, she lied to her mother about whether she brushed her teeth. And this rule says you've got to have somebody come forward and say, I have an opinion as to whether she's a truthful person or not. And then the specific instances of conduct can go in to express what their reasons were. But this is clearly inadmissible.
So I guess the issue here is...
If I may address the court.
Yes, I guess the argument from the defense, just to make sure I understand, the suspension would have to reflect bias or interest related to this particular case. Is that right?
Your Honor, my assertion is, if I may make the argument,
Yes.
she
she states in the agreement, Officer Platt waives any rights to appeal this agreed suspension and agrees no administrative or judicial body shall have the power to review this agreed suspension or alter the terms of this agreement. And she testified that she admitted that it's true that she failed to investigate the collision and was untruthful on information she supplied in her accident report. So it's germane to her functions and duties as a police officer in completing reports. What's at issue is whether or not she fully and accurately and fully investigated this case and included all the details of the totality of the circumstances, and what she is doing is blaming someone else. That's not my job. Like Chico and the Man, I don't know if you remember that, but it's, not my job. And you can't do that if you're a police officer, if you have a duty to fully investigate the case. And so this shows that when she says it's not my job, that she's being untruthful and failing to do her duties to do a complete fair investigation. And that's why it's relevant.
And I just want to, and this is the last thing I'll say, Your Honor, is to protect the record from our perspective. Mr. Luna was talking about, well, if she was 14 and lied to her parents, we're not trying to go into that. We're trying to go into, was there a finding of her being untruthful as a police officer? With regard to their arguments under the rules of evidence, the court well knows under the Code of Criminal Procedure, the highest law in the land is our constitutional rights. Cases like Davis v. Alaska have shown, no, a person's constitutional right to confrontation overcomes a simple rule of evidence that says maybe you can't go in and impeach that juvenile. It's the same thing, Your Honor, with the line of cases we provided, all United States Supreme Court cases, our right to defense. They all talk about, when it comes to overcoming things like the rules of evidence, the defendants, these three gentlemen, their right to confrontation, their right to put this witness in perspective, they are on trial for their lives, overcomes, and like I said, I would still say bias and motivation are always relevant. That's black letter law. It's relevant in every case. And the bias and motivation doesn't have to be for this particular case. It's the bias and motivation of a party. She has clearly aligned herself with the San Antonio Police Department, who rushed to indict these men without a full investigation. And once again, I just want to reiterate the fact that she was being disingenuous by saying, I don't know anything about this case, but let me rattle off this litany of what just so happened to be the exact facts of this case.
Your Honor, if I may, the witness testified she was called in to support the primary investigator, Detective Soto. She had specific tasks to set up video and to take statements of one of the subject officers. She did that. She explained how she did it. She explained she wanted to get his word. She did not editorialize it, etc. To put on her the burden of looking at every other related video when taking the statement of one of the accused, it's unreasonable. The defense is trying to daisy chain all of these events, and it's unduly prejudicial. It is inadmissible. It is wrong. If they have testimony they want to bring in to try to impeach the witness's credibility, then do so. But that document before you says that she agreed to, and as her own testimony, she was the one who was there, the allegations of untruthfulness were unfounded.
Okay, so is the defense trying to say that she failed to, right, obviously the argument is that she did not fully investigate this case. She has motive somehow or another to cover up this investigation. It was in this particular case. And you're saying that this extrinsic evidence somehow or another shows that she failed to investigate this other case.
That's right. And she's also admitted in the factual narrative that she's untruthful. She admitted that that's true, that she admitted to it. So whether there's a finding of the rule violation, the fact that she admitted that she was untruthful is sufficient to show she was untruthful.
And then, Your Honor, they will-
about fulfilling her duties to investigate a case.
And again, Your Honor, if that is in the document from 10 years ago and she does not deny it, then they can't try to impeach her with it. She has not denied it.
We're not showing it for necessarily for impeachment, but to show that it, under 404B2, that it's admissible.
I think, Judge, if I may just respectfully make a suggestion, maybe if the court would consider talking about, have you ever been reprimanded before in general for being untruthful in how you handle an investigation without going into the specific instance of conduct? My humble suggestion, after hearing all the arguments, you're the judge, maybe that's something the court can consider, Judge, I mean, to kind of rectify this, because with all due respect, I mean, it does appear that she's testifying differently, and I'm going to recross her, don't get me wrong, but when she's talking about, I know exactly why they were indicted. Now she's put herself into a different category. She said, I've seen nothing. She said, all I did was take a statement. All I did was do this. And now she kind of took a different step. So I think Mr. Del Bravo is saying is she has aligned herself not with an investigatory role and being objective, but being subjective with the government's position and the brass's position, not the membership, but the brass. In our opinion, falsely accusing these officers. So yes, I can impeach her, I can cross-examine her, I understand that. But now we're not getting into a specific instance of conduct in general, saying you've been reprimanded for not being truthful in how you handle investigations. She is testifying to an investigation regardless of her role in it, and maybe that is something the court would consider, Judge. That's my humble suggestion.
So I don't want to take issue with Mr. LaHood, but I think that what is worse here and why it's so imperative is that her testimony puts her duties and responsibilities in front of the jury in a false light, as if that was not her responsibility, when in fact it is her responsibility to fully investigate the totality of the circumstances, because what she's essentially admitting is that since she didn't tell Soto and no one else told Soto, that somehow or another, and again, I hate to use Chico the Man, but she's telling them it's not my job. And that can't be the case. And what we want to show is that, yeah, it is your job and you should have known better. And by saying it's not your job, you're not being truthful and candid with this jury. And that's relevant for purposes of presenting a defense for our client, Eleazar Alejandro and others.
I have nothing else to ask, Judge, but nothing else to add, Judge. Just, I don't believe she has admitted to it. I'll simply say that. Impeachment calls if she denies it, which she has not done.
All right. I'm sorry, you wanted to...
Well, I'm not saying we're trying to impeach her per se, Judge. If veracity is always at issue, Judge, with a witness. We all know that. Both sides know that. And so I think it's more in that vein. I understand what counsel's argument is, but we're not trying to quote-unquote impeach her specifically. It's veracity.
She's put herself in a false light, and we should be entitled to correct that false light. And I think that she essentially has opened the door by suggesting that she's never done anything wrong or incomplete in an investigation. If someone, she's essentially put her character into issue by saying it's not her job and she did a complete investigation. If someone were to say that I've never stolen before, and in fact they had stolen, then sure, the door would be open. So if she's opened the door, so when a witness opens the door to their prior bad acts, it's admissible. I think this court, on that basis alone, should allow this because she's put herself in a false light, trying to say I did a complete fair investigation, when in fact she didn't. And she knows better, and in fact, she has messed up investigations before.
Your Honor, and that's where counsel exceeds what he's trying to say. She never testified she did a full and complete investigation. She said her role was to take interviews of officers. One of them is one of the shooting officers of the OIS. She took 2 others, and she said, that is all I was tasked to do. She did not deny it, and then everything else counsel asked, if she did this, she did that, she responded, those were not my duties. on this case as she was assigned by her leadership. She has not denied anything. If the court were to allow it, I would continuation or a nuance of Mr. Hood's suggestion, then maybe the question might be, have you ever done an incomplete investigation and or been disciplined for it? But I would still come back to, she has never denied it, therefore there is no basis to impeach her with it.
Your Honor, the counsel's suggestion that somehow or another that there's no connection between her role in this investigation and this case is specious, and I'll tell you why. Procedure 707 is crash investigation, and she was a patrolman at the time this happened. She's not required under SAPD policy to investigate crashes. The traffic investigative unit made up of detectives is required to investigate. And so she takes part in the preliminary gathering of facts and information. And so there's an analogy to this case. What she's suggesting is that, oh, that was Soto's job, and so I can be incomplete, I can be inaccurate, I can have material omissions because it's Soto's job. That's the same thing that's happening here when she was charged with failing to follow Procedure 707 as a patrolman. She can't put herself in a false light. She has opened the door by suggesting that it's not her job, that she didn't do anything wrong, and she's not required to do a complete, thorough investigation and take a competent statement. That's why this should be admissible.
Your Honor, that is a blatantly ridiculous argument. The homicide unit works collaboratively, particularly when they have OISs. Detectives will come in, they're given different parts of that elephant to eat collectively together. She was doing her role. She said, this is what I was assigned to do. Had she been given additional assignments, I'm sure she would have carried them out. Along with, I'll still go back, it's over 10 years. If you were impeaching a witness in a criminal case, that is the nexus of too remote to bring up. It is an impossibility.
There is no time limitation when someone puts themselves in a false light. They have not addressed that she has put herself in a false light. She has opened the door by saying it wasn't her job, that she doesn't have to do a complete investigation. She's not required to look at the video. She doesn't need to do the totality of the circumstances. She has put herself in a false light. Because she's put herself in a false light, we're entitled to correct that. She can't put herself in a false light and then have the defense being unable to attack her credibility for putting herself in a false light.
All right. Just one final, Judge.
Yes.
She has testified that her duties were to take statements, I believe it was Officer Neary, Defendant Flores, and there was one other person. Did she set up interviews? And she set up interviews. My point is, she did those assigned tasks completely. They are not impeaching her because she did her assigned duties incompletely. They want to expand it when she was not the filing detective. She did not seek the warrant. She did not sign the warrant. She did not do anything other than the task she was assigned. And that she did completely and fully.
All right, so I've reviewed the law. If I conduct a 403, the prejudicial value is low. I think the probative value is low. I like the idea of splitting it. I'll let the defense ask her questions about it and only admit the document if it looks like defense, you can't do it without, you can't impeach her without the document. Her role was minor. So again, I'll let you ask questions about it, but at this particular point, I won't allow the admission of the document. Anything else?
Just for clarity, because I want to make sure none of us violate your instruction, Judge.
Yes.
So you're saying we can ask her about the suspension for untruthfulness in how she conducted an investigation, but not enter the document and leave it at that?
Yes.
Your Honor, again, if I understand that suspension, it was not for untruthfulness.
And you'll have the ability to redirect. Anything else?
All right for the jury? May be seated.
All right, welcome back, members of the jury. Defense?
Detective Flatt, you would agree that previously you were suspended by the San Antonio Police Department for violating certain procedures,
Yes, many years ago.
and you were suspended for failing to follow procedure 607, which includes impounding the vehicle, correct?
Yes,
And you were suspended for improperly failing to investigate a crash investigation as required by procedure 707.04.
yes,
And when you were suspended, the department found that you were untruthful on information you supplied in the accident report, correct?
that was written in the IA sergeant's summary.
In your suspension document, it states that, correct?
Yes, it does.
So, the chief of police determined, based upon the factual allegation, that you failed to investigate the collision properly and were untruthful on information you supplied, correct?
Yes, and I can explain that case if you want me to
Thank you,
get into that.
Now, you would agree with me that I don't think I need the sound on this. You indicated that you've never seen any other body cameras of other officers, correct?
I didn't view them myself.
Okay, so would you agree you never reviewed Officer Ramos' body worn camera?
No, I don't believe I did.
Look at this. All right. I'm going to represent to you that what we're going to see here, Melissa Perez throwing a candle through this open window. Would you agree with me that this window that we see, that I'm outlining with my cursor, is open?
It appears to be open.
It appears to be open, okay. Let me change the speed setting on this. Did you see Melissa Perez throw a candle there?
I saw someone come towards the window. I didn't see.
All right.
You can play it back.
Fair enough. It was pretty fast, so I'll play it in slow-mo for you. Let's see if we can see it in half speed. Did you see her throw the candle then?
I saw a female throw something out the window, yes.
All right. But you don't know that it was a candle, right?
I do not. No.
Okay, because it was too fast for you even at half speed?
Because I just can't see it.
All right, well, let's play it at, quarter speed.
at a quarter speed, did you see the candle?
I saw an object.
All right. So even at a quarter speed, it was too fast for you to see a candle, correct?
Yes,
All right. You would agree with me that when she threw that object, she didn't have any trouble throwing that object through the open window, correct?
correct.
So she was unobstructed when she threw that object, correct?
Yes,
All right. I'm going to show you one last, and you've never seen that video before, correct?
correct.
This is Officer Salinas' video, and, all right, we're at 1:40:38. This is Melissa Perez. It's 1:40:48, and notice where she's located. In 2 seconds, I'm going to represent to you that she's at this window swinging a hammer, and I'm going to slow it down since I want to make sure that you see it happen. All right, would you agree with me that she was able to swing that hammer out the window without any impediment or obstructions?
Did she knock the screen out?
Was she able to extend the hammer out the window?
Yes,
And she had no difficulty extending the hammer out the window, correct?
correct.
And you understand that Officer Salinas had pulled the screen and his head was inside the apartment at the time that she swung the hammer at him, correct?
If we could just watch it again so I can see it.
All right. Oops, we need to back up a little bit. Change the speed back. All right, you see at 1:40:49 that he's lifted the screen.
Yes,
And I'm going to represent to you that in the next second, we see that his head is inside that opening. And after I play the next second, I'm going to ask you if you agree with what I represented. Did he put his head inside that opening?
he did.
All right. And so when his head was inside that opening, she's swinging her hammer where his head used to be, correct?
Let me look at it again. Normally when I watch these things, I watch them many times. I don't,
In fairness to our clients, you would agree that you should have watched this before you took statements.
no, I don't agree.
You agree that she was able to swing that hammer easily out that window, correct?
Yes,
Nothing further.
Judge, even though I'm back here, I'm going to stay seated, if that's okay?
Yes.
If you'll take,
Yep, thank you.
thank you.
Detective, good afternoon. My name's Tom Nisbet, and myself and Christian Newman, we represent Sergeant Flores, okay? May I ask you some questions, sort of same parameters, but I'm going to move to a different topic. Fair?
okay, yes,
Okay. You're trained as an SAPD officer and trainings you've taken, like with Mr. Majeka on stress response in an officer-involved shooting, correct?
Yes.
All right. And it's actually called a stress survival reaction that an officer or a person undergoes when they're in that fight or flight response, right?
Yes.
Okay. It triggers, as you're trained, their sympathetic nervous system, and it has all these physiological effects on their body, right?
Yes.
Okay. It affects their physiology, meaning their body, but it also affects their psychology, meaning their mind, correct?
Yes.
All right. And you're trained that in a half a second, their heart can go from 70, 75 beats per minute all the way up to 220 beats per minute in a half a second.
I don't know.
You don't recall that from the
No,
training?
I don't recall that.
Okay. Do you recall learning that on average, the heartbeat does reach about 175 beats per minute within those incidents?
I feel comfortable to say it increases quickly.
Okay.
I mean, honestly.
That's fair, I'm good with that. And you're also trained that along with that heart response, physiological response, psychological response, there's a visual response that happens with the eyes, correct?
Yes.
Right? There's a flattening of the eyes and a tunnel vision type effect on what that person is focusing on.
Yes.
So in Alfred's statement, which you took, when he says he remembers seeing a hammer, it seemed larger than usual, that's consistent with the physiological effects that happen inside the human body during one of these critical stress responses.
Yes.
Also, the auditory system is affected, correct? Or ability to hear.
Yes.
Sometimes, or I should say, the training teaches you that sometimes people hear nothing at all, correct?
Correct.
Sometimes one or two occasional sounds.
Correct.
Sometimes a lot of noise, but maybe even an unrelated noise.
Yes.
Okay. When you were taking Alfred's statement, were you aware that he wears hearing aids?
I don't recall that, no.
Okay. That's not something that you remember learning during the interview process?
I don't remember learning that, no.
Okay. And then finally, going back to the psychological, that stress response can have a profound effect on someone's neural system, can't it?
Yes.
Okay. And so, I know you haven't watched the video, but I'm going to give you an example of something that the members of the jury may have seen in the video and ask you, is that consistent with the neural response, okay?
Okay.
All right. So in the training, the neural response is actually nicknamed in here brain fart mode. Have you heard this phrase before?
Yes.
Okay.
Not
It's
really.
not a scientific term, but everybody, we know, the members of the jury, we know what brain fart mode is, right?
Right.
And so if the members of the jury are watching Alfred after this critical stress response is triggered, walking around and he's just kind of clicking his radio, but he doesn't seem to be accomplishing anything for like 60 seconds after, that could be an example of being in brain fart mode, couldn't it?
Yes.
Okay. So, as a part of this training on the physiological response of the body, it also has a component of interviewing the person after they have been in this critical stress response, correct?
Yes.
All right. And the best practices state that that person should get 48 hours, 2 full sleep cycles before they give their statement. That's what the training says, correct?
That I don't know. I know that wasn't what we did at the time.
That's
Right.
Thank you
So
very
that's
much.
I don't know.
I'm not asking you what you did at the time. I'll represent to you what was done at the time is not consistent with the best practices because we know that he gave his statement to you around 8:35 a.m. that day.
Yes, I could agree
That's
with
what the
that.
timestamp on.
Right. Yeah, I don't know what time it began, but it was sometime during that time frame.
Okay, so we're gonna do quick math. The shooting happens at about 2 a.m. and the statement's happening at about 8:30 a.m. That's 6.5 hours.
Right.
And there's no sleep cycle that's occurred in that 6.5 hours.
Right.
It's not 24 hours, it's not 48 hours, it's 6.5 hours.
Right.
Thank you.
And then the federal government, for the feds, when they have officer-involved shootings, they actually have a mandated 72 hours. Did you learn that?
Statute relevance,
It's extremely relevant, Judge. I can go into why.
it's governed by state law, Your Honor.
I'll sustain. You can rephrase it.
In the best practices you learned during your use of force and OIS investigation training, the science of why you allow those sleep cycles before the interview was explained, correct?
I don't remember those details in the training.
Okay.
I mean, when you go to training, you take different things out of it. I don't remember all the science part of it.
To be fair, I have to explore a little more science.
That's okay.
If you say, hey, I don't remember that, that's fine, but I'm gonna explore some more science with you, okay?
Yes.
All right. 30% of what happened is all an officer can recall in the first 24 hours. Do you remember learning that?
No.
Okay. 50% is all an officer can recall in the first 48 hours. Is that something you recall learning?
No.
75 to 95% is recall for 72 to 100 hours. Do you remember learning that in the training?
No.
Okay. Do you, well, just to, I know you've already said it 10 times, but I'm gonna make you say it an 11th time. You weren't at the scene and you don't know what happened that night.
I was not at the scene, and because I don't want to be accused of anything here. I know some details, so I'm not going to say I don't know anything that happened. If you want me to explain, I could.
The question I'm asking you is about personal knowledge, okay? That's a term in the law, personal knowledge. I see it, I experience it, you're a person who was on scene. Do you have personal knowledge of anything that happened that night?
Not before I took his statement. No, I didn't.
And so, if the members of the jury have seen discussions about keys and entry points and bedridden old men and doors being locked and other doors being unlocked and assignment of duties and backing off rails and beanbag guns, if they've seen all that in the body-worn camera, that's the best evidence of what actually happened that night. You'd agree?
Yes.
Okay. And then we are in agreement that because of the stress response and the science that you've been trained on, an individual like Alfred, like Alejandro, like Villalobos, they could be experiencing major memory issues 6.5 hours later.
Yeah, people recall things differently, and based off what you said, the statistics.
Thank you for that. All right. Do you recall that the Axon system that plays the body cameras once they're docked and all that stuff was not working correctly that night?
No.
You don't?
No, I don't.
Okay. So, is it that you know for a fact that it was working correctly that night, or you just don't recall if that issue was happening?
I don't know about that issue.
Okay. Detective, you had a quote, and you said that I like to view everything that's pertinent before I make a decision. Is that?
When I'm an investigator, like the lead investigator.
I agree.
Yeah.
I agree.
It's different when you're not. It just is. I'm sorry, but that's how it is.
Like you go to a potluck dinner and you look at somebody else's beans and you're like, oh, I wouldn't have done it like that, but that's the way they chose to do it, kind of thing.
With beans, yeah.
You with beans. All right. And when you want to view everything that's pertinent, that would be all the details, right? Measurements, photos, the details matter. Can we agree on that?
Yes.
And if you didn't have all the information or you didn't have all the details when you made your decision, that's not the way you would investigate a case, correct?
No, I wouldn't.
Okay. You said person? circling back to the, just because it's not in the statement, right, doesn't mean it didn't happen in the body cam issue.
Correct.
Right. Just because it's not in the statement doesn't mean a reasonable officer couldn't have relied on it.
Couldn't have relied on this statement?
Couldn't have relied on things, what happens there? Let's say it actually happened, okay? I'm just gonna give a fact. There's an old man in that bedroom over there, okay? Does that fact appear in Alfred's statement?
No.
Okay. If 2 or 3 different officers tell him that on the body camera, that's the best evidence for the jury to consider.
Yes.
All right. And a reasonable officer could rely on, in the totality of the circumstances, information told to them at the scene while they're working the scene.
Yes.
Thank you. Pass the witness.
Detective Platt, when Mr. Cifuentes asked you about that past difficulty of Sergeant Sack could explain, what do you want to say?
I just want to say, because he's trying to make it look like I'm untruthful and I'm a liar, basically. And so, which I'm not. I had 2 years on the department. I was investigating a car. I was a patrolman called out to a typical crash on the highway. A crash report is a civil matter, and really my opinion on that is police shouldn't even respond to crash reports, is because that's between the insurance, right, and the drivers. Well, on this particular day, back at that time, 10 years ago when this happened, we only had Coban. We did not have body cameras. The Coban did capture audio. It was a 3-car crash, and one of the allegations was me as a patrol officer, I did not contact all the 911 callers. We do not do that as patrolmen. That's the follow-up investigator's job. I don't have the time, and we don't do that. We're only talking to the drivers on scene. So like I said, it was 3 drivers involved. One of them was a hit and run, and it left. One of the people, 2 people stayed. The person in the green truck and the person maybe, I think it was a white car, she stayed on scene. She was in the ambulance and she was being treated for no visible injuries, a partial side swipe. So it was a partial side swipe. The truck had spun and hit the wall and was all kinds of damage, but it was still drivable. The lady told me that it was the black car that hit her. It was recorded on my Coban. Why the IA investigator did not listen to that, instead took her word, because she came into the sub 2 weeks later to say I lied on the crash report and I put the wrong vehicle at fault. It was on Coban and recorded. And so, the 911 caller, which I did not contact, the 911 caller said the truck was driving kind of erratically, but the black car hit the white car on the 911 call. So it blew my mind that I got in trouble for this.
We would ask that Defendant's Exhibit 107 be admitted at this time, since they opened the door.
I'll sustain the narrative, any response to that.
And so I think we have the gist. What's your final point?
Okay, my final point is that day I learned that as an officer, you do not have the discretion that you think that you do to be able to help a citizen out when they're involved in a crash. That's what I thought, is that I could allow the guy to drive away rather than tow his car and he end up paying impound fees and all that stuff. I let him change his tire so he could drive off, or I think that's what I told him. He could change his tire, get a tow truck, whatever, because I felt it was his birthday and I felt pity for him. And then here I paid for it. I got a contemplated indefinite suspension that was dropped to a 1 day. I have never done it again, and part of the thing is if 2 weeks later I just would have made an additional report, a supplement that said she came in and changed her statement and said this person hit me, I would not be in the spot that I am right now or back then. So I changed my ways that day because of what happened to me. It was the worst thing that happened to me in my life and my career.
Thank you. When we began on direct, you said that you've worked approximately 40 to 50, been lead investigator for approximately 40 to 50, lack of a better word, conventional murders, non-OIS murders, correct?
Yes.
How many occasions have you determined probable cause and walked a warrant within 24 hours?
My cases, it would have been an on-site arrest or the warrant was not walked within 24 hours.
Okay, but is that concept appropriate to you? When do you decide to go get a warrant in an investigation? What do you have to have?
Probable cause.
Right. Is that the same in any homicide?
Yes, to walk a warrant for anything.
Okay. And if you have the evidence, is that what you expected to do?
If to write a
If you
warrant?
have the evidence to sustain probable cause.
Yes, if you have the evidence for probable cause for an arrest warrant, then we call it walk the warrant. You get the warrant issued.
And is that specific to violent crime?
No, it's all crimes.
On cross-examination, there was discussion about the relationship between your department's policy and the law. And you recall Mr. LaHood came up and reviewed a section out of Chapter 9
Right.
of the Penal Code.
Yes.
That section that he showed you, and I believe moved or asked the court to take notice, is that the only section in Chapter 9?
No, it isn't.
May I approach the witness, Sean?
Yes.
What section is this?
9.41, protection of one's own property.
Would ask the court to take judicial notice of Section 941A. A person in lawful possession.
Objection. This is not, the court has already ruled on this, that this is not being inquired into.
The court's...
Because you made a ruling, Judge, this doesn't apply to police officers. We talked about that outside their presence. I think they heard some of it. And so counsel knows that you made a ruling on this because that's not the law. It's not applied to officers. So it's a little frustrating, Judge. I don't know if you want to do this in front of the jury or outside their presence, but he knows this.
We have to.
This is an intentional violation.
Yeah, you got it, sir.
Sure.
seated.
Now, are y'all gonna be arguing? Just leave it, that's okay.
All right, you guys want to continue? Is there more?
I think the court heard all of our arguments, Judge. I mean, from the fact that, from your previous rulings to the way that the state is asking this question, to the fact that even though I know the government is saying that it's the black letter law, but these defenses to property, person, self are defenses to prosecution. So the state, in a very creative way, but it's an inappropriate way, is turning this into, number one, the deceased as the defendant, which she's not, although our argument is she should have been, but she's not. The bottom line is she's not in court sitting in one of these chairs. And then number two, they're turning this into a quasi-motion to suppress against the officers, not justifying the entry, so justifying deadly force against them. It's odd. No defense attorney has ever made that argument. No prosecutor has ever used this theory in defending or prosecuting an officer, or anybody for that matter. I asked Mr. Lunan last time, in his 37 years of experience, he said he didn't say anything, that speaks for itself. But as Jason said, there's no courtroom in Bexar County or any county in Texas where the state is making this argument, Judge. That's why early on I said this is ludicrous. We all agree. You have problems with it, Judge, because you've never heard it with all your experience. And this jury arguably is already confused. And so we believe, humbly and respectfully, that it takes a court's actual instruction to say this law doesn't apply, to make a ruling that this was not an illegal entry. I mean, you do this with motions to suppress all the time, Judge. And so this is confusing the jury, and they're hanging up on something that is not in the law. And so that needs to be corrected before the jury, Judge.
And Your Honor, I join in what Mr. LaHood says, and at the bench, Jay Norton said that 902 says that it's from the perspective of the accused. And I will want to reiterate that despite whatever the state may claim, we have provided you the Court of Criminal Appeals case of Mays versus State, where they said that they are not going to open the door to defense of property and have free season on police officers, because that's against public policy, and that the Castle Doctrine does not apply to police officers. And in the Mays case, they tried to argue the defense of property, and the Mays case made it clear that the Court of Criminal Appeals is not going to allow that. And what the state has done is repeatedly attempted to break the court's ruling by prohibiting this, and this repeated attempt to go there is intentional and is misconduct, and we've asked that the jury be instructed to disregard, and that the court give an instruction to correct this repeated violation and misrepresentation of the court's ruling in the law.
And Judge, I just want to say, and then you can respond, this is a defense, excuse me, Mr. Harris. We've already visited the Chuck Joyner issue. That was their designated expert. They gave us his report that went pretty much against their entire theory. A few days ago, they gave us notice that they spoke to Mr. Joyner again. Mr. Joyner once again told them that Melissa Perez was not allowed to use force against these officers. That's what their own expert is telling them. I don't know how much more in bad faith prosecutors can operate when everybody is telling them what the law is, and yet they come up with this. And 9.31 does not have any, it doesn't address law enforcement. The unlawful arrest, the illegal arrest, that specifically addresses police officers. It would be chaos if we were to logically follow what these men have been trying to promote. And the court has already ruled they can't use the phrase illegal arrest, so then they try to go around by saying, oh, well, they were illegally on the property, and so then she could use and they haven't even denied the argument that if she would have beamed one of these officers in the head with a hammer, as Officer Salinas said, hey, you guys were guilty of burglary of a habitation. This is open season on law enforcement.
You would have walked her on this issue, Dave. You would have. No. You would have.
Hold on a second. Stay.
Your Honor, and again, it is not my intent to go against the court's ruling simply in advocating, I'm as passionate as Mr. Hood is in advocating his point. That was my only point. As to the other aspects, defense wants to keep continually focus on the assault on Officer Salinas. Black letter statutory law is clear. To enter a residence, you must have consent, a warrant, or a recognized exigency. The facts, because this has all been before the jury, they know how long and the delay is. When we talk about, they bounce back and forth between policy, my intent is to show the department's policy 502, compare it to the statutory black letter law, they are verbatim. And such that when the jury has to ultimately consider the reasonableness, what the officers are trained, what's expected out of them to comply with statutory and black letter law in the same class, that is germane to assist the trier of fact in assessing their reasonableness. It, as they continue to say, we go to the totality of all the circumstance. And that is the only reason I intend to try to get to it. They went there with this witness on 9/3/2. I was trying to respond in kind. Understand how the court may rule. But the rest of it is relevant and germane.
Your Honor, if the defense is wishing to abandon relying on section 9.31 and 9.32, which requires for them to use deadly force, they have to be responding to unlawful deadly force. That's what's in those statutes, that they're responding to unlawful deadly force. If they're willing to abandon those and use the specific provision of 9.51 that gives the authority to officers to use deadly force in situations where it's an arrest or search, that's the more narrow provision that Mr. Del Prado had mentioned about. If they're going to rely just on 951, it doesn't mention in there unlawfulness of the force being used against them. Then they can rely on that. If they're going to abandon 931 and 932 and rely simply on 951, then we won't go there. We won't need to go there. Okay?
I'm not going to be held hostage to a misapplication.
But if they're going to use,
that's a misapplication of the law. We don't have to abandon anything. It's our
But if they're going to use 931, it calls for proof.
Of what?
To use force, they have to be confronted with unlawful force, and if she's not acting unlawfully under 941, then we ought to be able to point that out. We ought to be able to point that out.
Your Honor, if I could, I know that there's been a lot of talking. I have a different point that I do want to put on the record on behalf of our clients, because I think it's important when considering the prosecution trying to use a defense. The code, first of all, isn't built for that, because what is a defense? Because it's not an affirmative defense. What is a defense? A defense means that the people opposing that defense has to disprove that defense beyond a reasonable doubt. And it places a burden on us to disprove beyond a reasonable doubt that she was acting in reasonably and immediately necessary in defense of her property. So first it shifts the burden over to us, which is unfair. The code has no provision for saying that the state has to prove that beyond a reasonable doubt that she was acting in defense. And there's no charge that the court can give. Because the way the defenses work is when they assert the defense, usually it's because, as Jay said, the code is designed for the defendant to do it because the side with the burden has to disprove it beyond a reasonable doubt. Now, if they were allowed to assert that defense, it would push that burden on us. That's the first thing. The second thing, as far as this issue of unlawfulness, and as far as this issue of unlawful deadly force, this is what they're calling black letter law. It is strictly a matter of law. This would normally, if this were not a world that kind of flipped around, this would normally be a motion to suppress. For instance, a motion to suppress running with trial. And the court would make that decision about whether or not their entry was lawful, about whether or not they had exigent circumstances. So the court would make that decision of law. It's a pure issue of law that would not go to the jury unless there was an issue of fact in dispute, and then under 3823, the defense could bring that factual dispute to the jury to have them decide it. The problem the state has, though, is they don't have a right to have a 3823 instruction to the jury. So they can't do that. So there is no factual issue for the jury to determine. There is only a pure question of law. But even if they could do 3823, there is no dispute as to the facts. Whether the old man is there, that she cut the wires, she committed the felony, all of those things are completely not in dispute, and nobody has brought any of those facts into dispute. So they cannot get a 3823, but even if they could, they have not gotten what they needed to get to have a 3823, which is a legitimate factual dispute. So we're back to the point where I kind of said from the beginning, this is a pure matter of law that the court should decide and instruct the jury on. And the jury should be instructed that if the court finds, and let's say we're running this with trial, that obviously as the court you've needed to hear all the facts. I think you've heard most of them, but there are probably still some more facts, including some of the things that, some of the violent conduct of Melissa Perez from before that could also drive an exigency. Because as we talked about, exigency is objective, it's not subjective. So whether or not an officer subjectively knew this, exigency is an objective issue. And so all of these other things that the court may hear, I think ultimately the court can determine that they were either lawfully making an arrest inside of the home without a warrant or unlawfully making an arrest in the home without a warrant. But whatever that is, it would be an issue of law for the court to decide and not an issue of fact for the jury to decide. And that's where our objections have been coming from, because the defenses are not built for the state to use them because it puts a burden on us in order to disprove them. And that would shift the burden, and that's impermissible. So the defenses aren't used for that, and this is a pure question of law. A jury would never decide whether or not there's exigent circumstances for the police officers to go in. That would always be a question that a judge would decide, unless the defense brought up a fact dispute for 3823 instruction, which they do not have and they cannot get. And that's what I wanted to put on the record.
And just following on that one thought, for completeness, I believe giving them a defensive charge to use as a weapon is improper comment on the weight of the evidence because of all the effects that it has.
Well, 941 and 942 would not be in the jury charge.
So if it's not in the jury
Then
charge,
why talk about it?
they should not be allowed to put that before the jury.
All right, I'm gonna let the state have the last word.
Okay. With respect to Jay's comment, Mr. Norton's comment, the Court of Criminal Appeals has already ruled and allowed for a defensive instruction on the state of mind of the victim in using his ability to defend against a third person in a case where a defendant is charged with, I'll tell you the facts, the defendant is charged with aggravated assault, okay, against a man who was trying to enter into his home to protect his girlfriend who was being threatened by this man. And the jury said, or the state asked for, the court sua sponte said, this person who's trying to enter into his home, who was assaulted, knocked unconscious, and incurred serious bodily injury, the defense was claiming self-defense, just like here. Claiming self-defense, said, I have a right to protect this person from coming into my house. And the court said, well, the jury needs to know whether or not that person who was struck was acting unlawfully or not, because the defense is asking the court for a self-defense instruction. And the jury will be left without any guidance as to whether that person trying to enter was unlawful or not, unless I give them an instruction on defense of third persons. And the Court of Criminal Appeals approved that. It said, yes, the jury should know what that term unlawful means. Because in this case, Judge, what's going to happen to that jury when they go back there, absent this instruction, is they're going to say, what does it mean? What does it mean in 931 and 941? I'm sorry, 931 and 932, when it says that the officer has a right to use force against this woman, believing that she was using unlawful force against him. They're going to want to know, was she acting unlawfully? And they're going to look to you to give an instruction on whether or not she was acting unlawfully. And 941 gives you the guidance that they'll be seeking.
And I know you said the state had the last word.
Yes.
But they have played out how she has schizophrenia. And the Mays court basically pointed out that the person who was mentally ill in that case could not hold a reasonable belief. So they can't even lay the predicate.
That wasn't an awful risk.
They cannot lay the predicate for a reasonable belief. So in order to be able to get that, what they're requesting, they have to prove that there's a reasonable belief, even if you were to disregard all the arguments that have been made by my co-counsels that it doesn't apply. So they can't even lay that predicate that this person had a reasonable belief.
And then on exigency, Judge Bimperod has already made a determination that there was exigency, and he has reviewed all of the videos that have been introduced in this case, and for them to suggest that exigency doesn't exist because of SAPD policy and the law are synonymous is misleading. You know, for him to suggest that they're synonymous is not the case. The PD can have a policy more restrictive than the case law. And Judge Bimperod did say that the exigency was the fact that the old man was an invalid and she was not in her right state of mind.
All right, I said I'd let the state have the last word. Just a comment, Your Honor, on the Mays case, the facts there, clear-cut agency, ongoing assault. Police were rightfully in the house. This claim was made after they were rightfully there. The facts before this jury, through all the video, and it's going to continue to be hammered, is that this was a property crime. We've already been through this with Salinas, and the quote assault then happened approximately 90 minutes in. Thereafter, everything reacts to Officer Salinas. A separate set of facts where, as the time dissipates, the exigency to respond and pierce that home, that importance negates as that time increases. That is a simple fact. That is why the statute calls for consent, a clear-cut exigency, or a warrant. It's even in the body cams that are in evidence. Patrol officers are whispering about it. Do we have a warrant? Is anybody getting a warrant? That's going to be before this jury. Not to mention what Ms. Perez is also saying. To clearly 1405 has to be permitted to go into this.
All right. All right, it's 9:15. We're going to bring the jury back in. I'm tempted to let the officers go. All right, so again, I'm going to sustain objections to 941 and 942. They haven't been triggered by the factors related to 942. All right. Anything else?
We'd ask for an instruction to disregard.
Okay. I'll instruct the jury to disregard the last question. Are we going to continue proceeding this evening?
I would like to try so we can try to complete and move this witness along.
Okay. All right. Let's bring on suspect.
I assume, Judge, you're not going to want me to start crossing her tonight, right? You'll let him finish and then pass, and then we'll start tomorrow morning? Or no?
Monday.
Monday.
Monday at 9.
We're not
Saturday,
going
too?
tomorrow?
Saturday? No.
No problem.
Monday at 9. Scheduling issues.
We have documents now.
No, I got it.
There's other things.
Okay, that's Judge. Sorry, John.
Extra good instructions for this long weekend, please. Thank you.
We don't want him watching Nico on his TikTok and podcast.
Only David watches.
All right for the jury?
All right, welcome back, members of the jury. I'm going to give you instruction to disregard the last question asked. State, you may continue.
What about the instruction?
The instruction on 941?
Disregard.
Yes. Disregard any reference made to 941 in the question.
Detective, I want to go back to when Mr. Hood was cross-examining you and he came up with the code, and you recall when he read chapter 931, self-defense instructions?
We've read yes, a portion.
Okay, you recall when he did that?
Yes,
And you are familiar with that statute? It's part of your tools in a homicide investigation,
right, and I refer to it.
okay? What does the term provoking the difficulty?
Provoking,
There's no evidence of provoking difficulty here.
Overrule.
Thank you. What does it mean?
I don't know.
All right. May I approach, Your Honor?
Yes.
Can I take her on board, Art?
Yes.
So he asked you a specific question from the statute of provoking the difficulty. You heard him say that?
Yes,
And you honestly said you don't know,
yes.
correct? And you also testified that you have not seen all the body cameras like you would normally do if you were the lead investigator for this incident, correct?
Yes,
So if he's going to ask you about a statute that you don't even recall, and I'm not being disrespectful or mean, and then also you don't know anything about the facts, you have no way to apply the facts to the law that you don't know, correct?
I don't know that portion.
But he's going to ask you about that, so you can't answer a question about provoking the difficulty, and you have no idea, well, it doesn't apply here, but you have no idea if it would even potentially apply here, right?
Right.
No further questions, sir. So we asked that he's not going to this question. If he wants to propose her as an expert, then we'd like to do a 705 hearing, which we have a right to a Dahlberg hearing, and we'd like to cross-examine her extensively outside the jury's presence to show, with all due respect, her lack of expertise in this field.
Your Honor, if I could have the court reporter read back her answer to my question?
She answered my question.
I understand.
Yeah, and the parties can remember that the court can instruct the jury on the law.
Yes, Your Honor, but I believe I asked if counsel had read her 931, and I believe her answer was, I use that in my practice. And I'm just following up and exploring that.
But that was not what we objected to. We objected to provoking difficulty.
It is a portion, it is a paragraph under 931, which she has testified she uses in her job.
Well, Judge, if you'll recall, I asked her about 931B2 specifically, and she read it. I didn't read it, by the way, and she didn't recall it. We went over it. You talked about resisting arrest.
And she's not a fact witness, right? And she's not a legal expert. She's not sustaining the objection.
You testified on direct with Mr. Hood that the totality of the circumstances are important when thinking about an arrest.
Yes.
And can you expand? What do you mean by that?
By reviewing all of the facts in the case, everything that you know. That's basically the totality.
You also testified okay, and I recall a statement, I think it was when Mr. Cifuentes came on, and you said you try to put yourself in the shoes of the person you're interviewing or the parties. You recall that line of questioning with Mr. Cifuentes?
That I said I put myself in the shoes?
I would object to him misstating the question or the testimony.
All right, Will, what's your question?
I'm simply going through my notes. I'm asking if you recall that.
And Your Honor, his notes are not paraphrase of the prior testimony.
All right, let's do the question.
I apologize. If I am misstating, I'm trying to explore your do you remember that discussion?
I don't remember saying that I put myself in the shoes.
Okay, thank you.
You said you don't remember, so.
I do not.
Okay. Further on with cross-examining Mr. Cifuentes, there was discussion about exigent circumstances. And he indicated there being no time to react or decide. You had a comment back on that about a barricaded subject. What was your feeling to his statement?
Objection, she doesn't know the facts of the case, and so she can't have feelings about whether Melissa Perez was in fact a barricaded subject.
I'm asking her to follow up with what she has already told counsel on cross-examination.
She's not an expert.
I'm not
And
asking.
she doesn't have the factual knowledge of all the facts.
He elicited the response on his question, Your Honor. I am redirect. I am trying to follow that up.
You can rephrase your question.
Okay? Do you recall that line of questioning from Mr. Cifuentes?
Not verbatim, I don't.
Would it be possible to have a court reporter go back to that portion for the question and the answer?
I would object to the court reporter going back to the question. It's not proper for cross-examination.
I'll let her do that, but that way you can get the question in. Okay.
Take me to it, Judge.
Okay.
Judge, I have it. You want the answer?
Well,
Both of them?
it's the question and then the answer.
You ready?
Yes.
The question from Mr. Cifuentes was, an officer can ask An officer can ask endless questions when taking action, and being cautious is being urgent and of the essence. The answer is if you depend on the circumstances, if you have exigent circumstances, that means there is no time. If you do have time and you are able to back off and able to contain, and you have more of a barricaded subject, then there is time to communicate. Give me 1 second. Okay, I'm ready. Yes, sir.
Okay. Are you familiar with the term of a barricaded suspect?
Yes.
What is a barricaded suspect?
A person who is in a location and essentially they're barricaded and usually armed.
Okay. And what is unique about having a barricaded suspect, from your experience, if you know?
With a barricaded suspect, normally, if they're not a direct threat to you, which usually they're not if they're barricaded, you back off, you contain, communicate, control a scene, call SWAT, all of those things.
Okay. Later on, Mr. Nesbitt, we talked to you about the stress responses that an officer has if he's had to use deadly force. Were you familiar with some of the data and statistics he was referring to?
I was familiar with I'll just call them symptoms, not the specific numbers to the statistics, but yes, I've heard of those.
And I agree with him that those would be something that an officer who's used force would respond to. My question is, in your experience, you've investigated homicides, are those unique just to police officers?
No.
So people you've had to talk to or interview in relation to your investigations, do you see some of those same reactions when you talk to them?
Yes.
Do you still talk to them, or do you give them 24, 72, 48 hours?
We interview them right away.
Why do you interview them right away?
So they can tell us exactly what happened right after the incident happened. They can tell us whatever details they recall immediately.
Is it important to get that information as soon as you can?
Yes.
I believe all counsel have talked about split-second decisions. Do you recall those lines of question that an officer has to react?
Yes.
If a pattern of behavior is repeated multiple times, would you call that a split-second decision?
Perception of vagueness, it's complex when you really think about it.
Okay. If you know in advance how someone's going to react, would you call that a split-second decision?
No.
And I will pass the witness.
All right, members of the jury, I'm going to go ahead and break for the day. It's 5:33. I'm going to give you all a break tomorrow. We will not have court this trial tomorrow. Come back Monday, no later than 9 o'clock. We expect to go through the entire day. Oh, let me give you all these instructions.
Wait, what time? What Monday?
9 o'clock Monday. Make sure that you do not in any way speak to anybody about any of the evidence in this case. No matter who it is, your best friend, family member, whoever. Make sure you do not do any sort of investigation. Do not look at the news media. Don't go online and look anything up. Zero information outside the four walls of this courtroom. All right, we'll see you Monday.